All rise.
Be seated, please. Ton of search warrants. That's why I'm out here late. Wow. Amy, make sure somebody. Oh, that's all right. I'm sure they know how to take care of it. Okay. Good morning, Ms. Trombley.
Good morning, Judge. How are you?
How about yourself?
Pretty well, thank you.
Good. All right. Just give me the one with Ms. Trombley. I'll write that.
That one's already done. On top.
Okay. Priority waste.
Yes, good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
25T646-026A and B. Okay, your name?
Elizabeth Trombley appearing on behalf of Priority Waste.
All right, so we have a civil infraction and we have you guys need to discuss this further, right?
Yes, I'm just requesting an adjournment, Your Honor.
All right, does your client stand mute, waive formal reading for
Yes.
purposes of arraignment on the misdemeanor?
Yes, Your Honor.
I'll enter a not guilty plea, $100 personal bond. I'll give you the adjournment. Give me a couple weeks down the road, Amy, please.
August 14th at 9:15 a.m.
August 14th at 9:15, okay?
Perfect. Thank you, Your Honor. Have a good day.
You too, thanks a lot.
Yep, bye.
You. Amina Ehab Alhami Nassif, 25T645912. Counsel, is he out there?
He was out there and met with the prosecutor, but he's no longer in the.
Mitchell Jeffrey Wilson, 25G306474. Come on up here, sir. Yeah, you don't qualify, sir. Your name?
Mitchell Wilson.
What are you driving like this for? You just don't qualify. You got 4 prior moving violations on here. I'm sorry.
Yeah, I was trying to get it down to.
Yeah, well, you're not going to get that from me. Okay, so you can go talk to him again, or you can request an informal hearing.
Okay.
What do you want to do? You got to be careful driving.
I don't know, I rolled through a stop sign.
You want to go talk to the department rep again?
Yeah, do I just knock on that door again?
I'll have the file brought over, okay?
Okay, thank you.
All right, Otero, Davidian, Jose Otero, 25T646-046A and B. Your name?
Davidian, Jose Otero.
Good morning. You're charged with animal violation, no license. That's a misdemeanor. And then you're also charged with grunt dog at large. So that's a civil infraction.
Yes, sir.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No.
I'm going to go ahead and arraign you, and then I'll send you to the prosecutor. It's alleged that you did own a dog that was on Cleveland near New York Street in Trenton at 2:20 p.m. on July 7th of 25. That is a misdemeanor, no license, punishable by up to 500 fines, 90 days jail, costs, or all those. And then the dog at large is a 0-point civil infraction. You understand that?
Yes, sir.
Now, on the misdemeanor, these rights apply. Did you sign the advice of rights?
Yes, sir.
Did you read it and understand it?
Yes, sir.
If you plead guilty at any time, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
Yes, sir.
I'm entering a not guilty plea. I'm giving you a $100 personal bond. Your dog, what kind of dog is that?
Pit bull.
Dog is to remain in fenced-in yard or your house or on a leash, listen to this very carefully, or on a leash equipped with a muzzle. You understand that? A muzzle? Do you understand that?
Yes, sir.
So do not have that dog out of that yard or out of your house without the dog being equipped with a muzzle, on a leash, and accompanied by you. Do you understand that?
Yes, sir.
You need to be accompanied by you, the owner, or other suitable adult, okay?
Yes, sir.
Also, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. So I'm going to hand this off to the court officer who will take it to the prosecutor and you'll meet with the prosecutor. Any questions?
No, sir.
And I'm entering a plea of denial on the civil infraction. Good luck. We still don't have that lawyer here?
No, I'll try to call him, Judge.
Please, thank you. Marcus Adam Ledyard, 25B1477098. Could I have Regwinder Chahal seated at this table, my right, your left? And also Manuel Quatrin Velez seated at that table, right there at that table. Your name, sir?
Marcus Ledyard.
You're late.
I wasn't late.
You're not late?
I said 8:40. I was here.
You're supposed to, you guys can have a seat. Seat. There you go. $75 a week you were supposed to pay, right?
Yes, I was.
Hang on. What did I tell you when I gave you that payment plan when you were supposed to pay $75 a week starting April 7th? What did I tell you?
I mean, so, hey, a few things happened, but, you know,
What else did I tell you? If you didn't have the money.
I'll call you and let you know. To call the court now.
Call me, call the court, we'll get on Zoom, and I'll give you an extension. Right?
Yes.
Or come in and talk to me on or before the due date, and I'll give you an extension, right?
Yes.
Why didn't you do that? It's not that hard.
I just had a few things happen.
That's okay, I get it. That's why I tell everybody, you don't have the money, come to court and talk to me on or before the due date. How much do you have today?
Like 160, maybe something like that. 160.
Can you pay that today?
Yes.
Now listen, I'm
How
gonna
much
give
my
you,
old total now?
you owe 281. I'm gonna give you a payment plan, but you gotta show some respect and call the court if you don't have the money. Is that fair?
Yes.
Okay. You pay 160 today, and you tell me when you can pay the balance. How about if I set you,
Couple weeks later.
how about if I set you up on 40 per week? If you can pay it earlier, that's fine. Beginning August the 15th, how's that?
That's fine.
You can do that, you think?
Yes.
If you don't have the money, what are you gonna do?
Call the court.
And we'll go on Zoom, or you can come in here on or before the due date, okay?
Yes.
All right, best of luck to you. So go down the hall, pay 160, then 40 a week starting in, on August the 15th. Best of luck. Regwinder Kaur Chahal, 25T645897. Good morning.
Good morning, sir.
Your name?
Rajendra.
You're charged with just not having your license on you. I can read the charge, send you to the prosecutor, or I can give you a lawyer, whatever you want.
Excuse me? Sorry.
It's okay. You have the right to a lawyer. If you want me to give you a lawyer, I will give you a lawyer.
No, sir. I want.
Okay, so I'll go ahead and arraign you, and then you can go talk to the prosecutor. Is that fair? I'm gonna explain the charge and the possible penalties, and then you go talk to the prosecutor. I'm sure the prosecutor's gonna be reasonable with you, okay? Fair enough? You understand that?
Yes, sir.
On June 26 or 25, the police think you didn't have that you were operating a motor vehicle and that you didn't have a license with you on your person on Fort near Vreeland and Trenton at 12:32 in the morning. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yes, sir.
Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. You still wish to waive your right to a lawyer. You still wish to give up your right to a lawyer.
No, sir.
You want a lawyer now?
No, sir.
So you waive your right to a lawyer, right?
Excuse me?
You're giving up your right to a lawyer, right?
Lawyer? No.
Okay. So I'm gonna enter a not guilty plea. I'm gonna give you a $100 personal bond. You don't have to post any money. We're gonna send you to the prosecutor. You're gonna go talk to the Trenton City Attorney. I'm sure they're gonna be reasonable with you, okay?
Okay.
So you can go out in the hall. My court officer will bring this file to the prosecutor and they'll call you out, okay?
Okay, thank you.
Do you understand?
Just go have a seat in the hall.
Hang on one second, hang on one
I'll be right
second.
there with you.
Here. Stand right there, stand right there. I want to make sure you understand. Do you understand everything that's going on here?
Sir,
I just explained to you the charge and the possible penalty.
passport?
Possible penalty.
Oh,
I told you what the possible penalty is, right? I said it was, I'm just telling you what it is. It's up to, I'm just telling you the maximums. I have to tell you the maximums. Up to $100 in fines, up to 90 days in jail, plus costs. I don't want to scare you. I'm not going to send you to jail, but I have to tell you what the maximums are. Those are the worst things that could happen, but they're not going to happen. I'm not going to send you to jail because you didn't have your license with you. So go talk to the prosecutor, see what you can negotiate with the prosecutor. They'll write up a plea form, and then you'll come back in front of me. Okay?
okay.
You understand that?
Yes, sir.
All right, good enough. Good luck. Quattro. Manuel Ivan, Quattro Velez.
Go have a
to the
seat.
podium, 24F 243 103A. Good morning. See, he's got
Man, have a seat in the hallway.
hallway, man.
Grab your stuff.
You have to go talk to the prosecutor. So they got to go to the Flat Rock prosecutor to have him dismiss this, John. Go out in the hallway and the prosecutor will talk to you. He'll fill out a stip form. He'll send it in and then I'll recall you, okay? Ross. Deviante Z1 Ross, 25T645998A and B. Your name? Deviante what? You're charged with driving on a suspended. You also have a expired plate. That's a B file. You have the right to a lawyer. If you want one, I'll give you one. Do you understand that? Do you want a lawyer? I'll go ahead and arraign you, and then I'll send you to the prosecutor. On July 8 of 25, the police think you were operating a motor vehicle on Fort near Sibley and Trenton at 9:13 a.m. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that? Did you sign the advice of rights? Did you read it? Did you understand it?
For the most part, yeah.
I can't hear you.
For the most part, yeah.
Okay, so tell me what part you didn't understand. If you plead guilty, we're not gonna have a trial. Do you understand that? If you plead guilty, you're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right to remain silent. You're waiving your right to a trial of any kind. You understand that?
Yes.
All right. Now, if you plead guilty, you understand there will be no trial. You're giving up your right to a jury trial. Do you understand that?
Yes.
You still wish to give up your right to a lawyer?
Yes.
I'll enter a not guilty plea, $500 personal bond, okay? You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to send you over there to the prosecutor, and you'll come back in front of me either way. I'm entering a plea of denial on the expired plate charge, okay?
What does that mean?
That means I'm saying you didn't do anything wrong, to put another way. And you go negotiate this with him. We'll be fair with you, okay? Good luck. Segovia? I got a note here, does not speak English. This is file 25T645763A, B, and C. Hola,
Hola.
what's your name? I know, you speak Spanish? I'm gonna get you an interpreter. No, I know. We're gonna get you a Spanish interpreter, okay? I don't know how we can do that. I'm gonna reset the arraignment and pretrial. I need to learn how to speak Spanish. You know that? A little bit, enough to.
You need an in-house interpreter.
Yeah, I know.
Every day.
We're getting a lot of them. Listen, Spanish interpreter, Espanol. Listen, I'll get you one. Translation, I don't know what to say. Amy, point out the date to him. Try or have somebody try to explain. I'm going to get him an interpreter, and I'll just let you get the new date, okay?
Yep, Judge, we use Google Translate. It works pretty well at the window, so.
Perfect. See, I learned something today, John.
Yeah.
We have that down there. Go down the hall, all the way to the end of the hall. Thank you. Good luck. Nicole Marie Mayros, 25T646067. Be right with you. Your name?
Nicole Maris.
You're charged with no license on the dog.
Yeah.
You have the right to a lawyer. If you want one, I'll give you one.
I don't think I need one.
I'm going to go ahead and advise you, on July 8 of 25 at 1:17 p.m., it is alleged that you did have a dog that was on Jackson Street near Benson in Trenton that was not licensed. You got to get a license. That's a misdemeanor, punishable by up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes, sir.
Did you sign the advice of rights?
I believe so, yes.
This document, did you sign it?
Yep.
Did you read it?
Yep.
Did
I
you?
mean, I haven't really read it, no.
Don't ever sign your name. What if we just had you sign over your
I
house?
didn't sign this one. Is this the one you're talking about? I signed the one that has like 4 spaces for a signature.
All right, let me just go through your rights. You have the
Okay.
right to remain silent. You don't have to say anything.
Okay,
You have the right to a trial by court or jury. You have the presumption of innocence. They have to prove you guilty beyond a reasonable doubt. If you plead guilty, you're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right to remain silent. You're waiving your right to trial. You're waiving your presumption of innocence. You're waiving the right to bring in your own witnesses and to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, again, you're giving up all those rights and there's not going to be a trial. Do you understand that?
yes.
Now, do you still wish to waive your right to a lawyer?
Yeah, I believe that.
I'll enter a not guilty plea. What kind of dog is that?
Australian Shepherd, and I have just a dog I found in the city of Detroit on the street. I saved on.
Okay, hang on a second. You know you have a warrant out of this court. Are they checking these warrants?
That warrant is, I paid a ticket a couple days ago and your guys' computer system was down because of the storm a couple days ago. So they were supposed to actually fix that for me.
Did you pay the ticket?
Absolutely, yeah.
Okay, well, this is,
I have the paper. and
hold on, I
papers.
believe you. I believe you.
Yeah,
The-
she doesn't have a warrant, Judge.
Yeah, this was run July 25th. Okay, I didn't know that you came in and paid it.
I hope they updated that though.
They will not have a warrant out for your arrest.
Okay.
Okay, so give me a bond sheet. I'm giving you $100 personal bond. You cannot leave the state without the consent of the court or violate any law.
Okay.
You must appear in court as directed. You are going to have to keep that dog.
I actually have a question, if I can ask a question.
Wait 1 second. That dog is to remain in your home. To remain in your house. Fenced in yard. Or, and I realize there wasn't a dog bite here, but or on a leash equipped with a muzzle. And accompanied by you or another suitable owner.
Morning, sir.
Morning, good morning. Okay, in the meantime, I'm gonna let you go talk to the prosecutor. Entering a not guilty plea. If he doesn't give you what you want, then you come and tell me you want a lawyer, but either way, you're coming back in front of me. Do you understand that?
Yes, today?
Yes,
Just a
ma'am.
little bit?
Yeah, okay.
Yep, thank you.
Do you have a question?
I thought they were on a 2-year license, but turns out they weren't.
We'll tell the prosecutor all that,
Okay.
okay? Good luck. Mina Ehab Elhami Nassif, 25T645912. Good morning, your appearance?
Good morning, Your Honor. Yes, Matthew Henry appearing on behalf of the defendant, Mr. Nassif.
You are going to plead to impeding the obstructed vision to be dismissed, and you're authorized to enter this plea on behalf of your client, true?
That is true, Your Honor.
To the charge of impeding traffic, responsible or not responsible?
Yes, responsible.
Plea is accepted, obstructed vision's dismissed, 160 is the fines. I'll give them till August the 7th to pay. They can go on 33court.com and take care of that, okay?
Thank you, Your Honor.
Have a good day.
Thank you as well.
Yes, something.
Yes, I do, Your Honor. And Mr. Kraft, it's arraignment for trials.
Okay. Was Rena Barnier in here yesterday?
Yes.
What did they do? Got papers here. Stephanie Marie Kraft, 25T644890.
Good morning, Your Honor. Mr. Junkie, very good. My client approached and stands to my meeting.
Ma'am, your name?
Stephanie.
All right, so for purposes of arraignment, she stand mute, wait for my reading.
Yes, Your Honor.
And then there's going to be a plea to allowing an unlicensed driver to drive, the suspend to be dismissed. She has a valid license now, true?
Correct, Your
Is that what you want to do, ma'am?
Yes.
If you plead to that, that will not be reported to the Secretary of State. The possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand in advice of rights? If you plead guilty, you'll be giving up all those rights. There will not be a trial then. Do you understand that?
Yes.
To the charge, allowing an unlicensed driver to drive, how do you plead? Were you in control of a 2014 Ford that was being operated on Harrison near Nichols in Trenton on June the 9th of 25?
Yes.
And did you know you were suspended, revoked, or denied?
No.
Hang
Your
on.
Honor, we'll stipulate that at the time the license was suspended, although unaware of it, ignorance of the law is not an appropriate.
Good answer, Mr. Shink. All right. All right, let me see this. Why was she
She
suspended?
had an outstanding ticket or some other scenario that momentarily suspended her license upon
receiving, it was, oh, I understand, Judge, she had made a payment on a ticket through Venmo, she thought that it had, oh, I'm sorry, she had thought she had renewed her license and. the payment
Because she
didn't come
was
through.
suspended because of the impaired charge, right?
There was a sanction regarding her license, she had thought she had paid the reinstatement fee.
Right.
It didn't go through,
Right.
she had fixed it immediately.
Return payment suspension, I got it. All right, anybody force you to plead guilty? Please accept it, suspends, dismissed. Anything, Mr. Shemke?
Your Honor, she came here with a valid driver's license, I know that's full, this court, I respectfully request leniency and any admonishment.
100, anything you want to say? 100 fines, 125 costs, 75 victims' rights, $50 justice assessment. Totals 350 or 60 days, okay?
Your Honor, if possible, can my client get 30 days?
Does she have any money today? Where do you work? How much do you make?
15 an hour.
Let's make it 60 per week and I'll start it beginning August the 8th, okay? That's next Friday. You can do that, right? If you don't have the money, you call the court, I'll go on Zoom with you, or you can come in here on or before the date. I'll be glad to give you a extension, okay? Just don't ignore me, all right? Good luck.
Thank you, Judge.
Thanks. 24F 243-103A. People against Manuel, Ivan, Quatrin, Velez. 24F 243-103A. Come on up here. Your name? Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. You swear to tell the truth?
Yes, Your Honor.
Okay. You all right?
Yes, Your Honor.
Since you were in front of me when I sentenced you back on February 6th of 25, have you been arrested?
No, Your Honor.
Any new charges pending?
No, Your Honor.
Good job. You were compliant. Prosecutor moves to dismiss. You're all set. Case dismissed. I wish you well. Good luck to you. You're welcome. Robinson, have a seat up here, my right, your left. Mitchell, Jeffrey, Wilson, 25G306474. Your name?
Mitchell Wilson.
All right, so he's going to reduce it from a 3-pointer to a 1-pointer. You're going to plead to 5 over, right?
Yes,
To the charge 5 over, responsible or not responsible?
responsible.
I'll accept the plea, dismiss the original charge. Listen to me, Mr. Mitchell. Mr. Wilson. You like insurance companies? You want to give them your money?
No, and I haven't got a ticket in like 3 years. I was paying $954 and I finally got it down to $300 a month and I was happy with that.
Well, you had one in 19, 22, 22, and 23, so it isn't exact, and it was the latter part of 22. So just, I'm just telling you, you got 4 tickets on here, and that doesn't include anything that's not showing on here. You got to slow down. Speeds accepted, stop sign dismissed, 175. You can go down the hall and take care of that, all right?
Thank you, Your Honor.
Please slow down for your own sake.
I will have
We
you.
don't want you to hurt anybody or your good-looking face there, okay? Nicolian Chevalier Robinson. 24F243-037. Mr. Robinson,
Good morning.
long time no see. Not that long, though. How long's it been?
Maybe a month or two.
Yeah, I know. It's not that long, right? You got a show cause here. They think down the hall, the probation department does, that you violated probation in that you failed to refrain from consuming alcohol or drugs, testing positive on a chemical test on July the 29th of 25. July 9 of 25, my apologies. If you have no prior technical violations, if you plead guilty or if you're found guilty, you could get 5 days here. Do you understand that?
I don't understand.
Did you sign the advice of rights?
Yes, sir.
Did you read it?
Yes, sir.
Understand it?
I did.
If you plead guilty, you'll be giving up all those rights and there will be no hearing. Do you understand that?
Yes, sir.
All right. You have the right to a lawyer. If you want one, I'll give you one. If you want a lawyer,
Yes.
I'll enter a not guilty plea for you. We will set this, you're going to go talk to the lawyer now. All right, and I'm entering a not guilty plea, and then you'll come back after you talk to the probation lawyer, which should be who? Looks like Mr. Shemke. Okay. Okay, arraignment attorney slash probation, I don't know. So you can go right out in the hall, you speak to him, you come back in front of me.
His name was Simpson.
Just have a seat in the hallway.
Shemke, I believe, yes. Anything else ready down there?
Because sometimes they'll do that.
Good morning, Deputy. How are you today?
Good morning, Judge McNally. I'm doing fine. How you doing? It's almost Friday, sir.
I get it. It's awful ugly out there, though. Wow. I'm supposed to play golf tonight.
It's a little rough.
Yeah. So you have Mr. Bankovich here, right?
I do, sir.
Can is he up for pretrial? Is that what he's doing? Yep. Do you know any? Is Mr. Bankovich up for pretrial today?
Yes, that's what I have on my docket, Your Honor.
Yep, an arraignment pretrial. Mazin met with him.
Okay, we're gonna give him a lawyer right now.
He already met with a lawyer, Judge.
Oh, he did? Who's this lawyer?
Mazin.
Okay. Okay.
I may have jumped the gun. I just saw he was in custody and got him in with Mazin.
All right.
I'm actually on my way in on that one.
Mason has that one.
We'll get Mr. Gaith in here momentarily. Kevin Joseph Connors, apparently he's already talked to lawyers, so we'll get him to zoom in and we'll go for their deputy, okay?
Sounds good, sir. Thank you.
Thank you very much.
All right, good luck.
Kevin Joseph Connors, 25T645760.
Judge, does he have an attorney?
No.
Okay, I didn't know if Derek was an attorney's name. Yeah, I have no one checked in on that.
Well, he already met with the town city attorney, it looks like. I hope he knew he had to come in. Hey, Will, can you call out for a Kevin Connors? I don't know. I hope he didn't leave. It's a Trenton prosecutor. See what they reduce it to impede. I'm ready to go, but I don't have he isn't in here, so. Thanks a lot, Will. How you doing, Mr. Gaith?
Good morning, how are you?
Good. Ugly out there.
Judge, for Mr. Bankovich,
Yeah.
he had another case in front of Judge Hessen.
Yeah?
We combined the two since prosecutors agreed to dismiss Judge Hessen's case.
Okay.
We bring that in front of you today, just.
Okay, no problem. I'll just take it and dismiss it if that's what you want me to do.
Yes.
So he's gonna plead on mine, is that the deal?
Correct. He's gonna plead his charge to yours and then they're gonna dismiss Judge Hessen's.
Okay. Would you try to tell Judge Hessen's judicial clerk so they don't,
They've already, the sergeant's already told Carl when he went and grabbed the file.
Sir, what are you here on? Are you the lawyer?
Yes, sir.
Did you file an appearance?
Yes, sir.
I don't have an appearance from him, Amy.
Is
What?
his last name Derek?
Yes.
Yes, it is. Okay, you're at Mr. Myers Law.
Correct.
I want Kevin Connors here.
You want Mr. Connors here?
No, I was gonna mess with him though. Okay, just let me get through this one and I'll get you out of here.
Thank you.
I'm sorry, I didn't see you had a lawyer. It wasn't written on the file. Okay. Donald Allen Bankovich, 25G306532, 25G306489. Mr. Gaith, your appearance.
Judge Mazin Gaith, on behalf of Mr. Bankovich, here to
All right, Mr. Bankovich, your name?
Donald Allen Bankovich.
Does he stand mute, waive formal reading on Judge Hessen's case?
Yes.
And he also stands mute and waives formal reading on my case, true? All right, so, and now he's gonna plead on the trespass case in front of me out of Gibraltar, and they're going to dismiss the other, right?
Correct.
Is that what you want to do, sir?
Yes, sir.
If you plead guilty here, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, sir.
Did you sign an advice of rights? No, you did not. Of course not. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You enjoy the presumption of innocence. If you plead guilty, you're giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. Is this what you want to do?
Yes, sir.
Charge of trespassing, how do you plead?
I'm guilty, sir.
On July 7 at 25 at 1:45 PM, were you at 28443 North Gibraltar Road in Gibraltar?
Yeah. According to the file, yes, sir.
You'd been trespassed from the place. They told you and informed you they did not want you to be there. Is that true?
Well, sir.
Is that true or false?
Yes, sir.
But you still went there?
Sir, I have a boat slip there, sir. I have a lease. Like, it's like I have an apartment and you tell me not to go to my apartment because I'm trespassed.
Well, I don't know what to tell you. The owner of the property can tell you they don't want you to be there.
Well, sir, may I speak? I have a lease. I signed a lease.
I
sir.
get it. I get
Okay.
it. But is that the owner of the property that told you you can't go there?
I can't know. I don't know who the owner was, sir. I don't know the owner, which property, the Gibraltar Boatyard.
Oh, and Detective Robinson, will you? Or the city attorney for Gibraltar, whoever's available.
They asked me not to go into the restaurant, sir, and I didn't go into the restaurants. So I'm very confused, sir.
Well, let's unconfuse you. How's that? Let me figure this out.
Yes, sir, please. May I speak though?
No, let me get the lawyer. You got a good lawyer here, and we got a very qualified prosecutor in here. Mr. Langtot, your name?
Good morning, Your Honor. Todd Lantot.
So this gentleman, and if the detective could come in too, I'd like to hear, I think, I arraigned Mr. Bankovich. I set a bond on him because I was told at the time of the arraignment or the signing on record that the defendant had 20 or so guns in his boat, that the people were in fear of him. And that's why I set the bond in part. And then he's got 2 trespassing charges here, and he's raising the issue. He said he was told not to go back. Didn't I tell you not to go back there too, didn't I? When did I arraign him, Amy?
I haven't been back since you told me, sir. I've been in here since you arraigned me. I've been here.
So I'm trying to figure this out. Hang on. Tell me your name too.
Sergeant Gary Robinson.
I'm just trying to figure out what's going on here. He says they leased him a boat slip. Is this the same owner of the property? Who owns 28443? That's Humbug, right?
I believe that's Humbug.
And Humbug trespassed him?
He's been trespassed, yeah. He does not have a boat slip there. He was buying some boats, 2 or 3 boats from the property, and they don't want him there anymore. They're trying to get him out of there.
Do you have a boat there?
I have a signed contract, sir.
Sir, I didn't ask you that. Do you have a boat there?
Yes.
You have a boat there?
Yes.
Your Honor, he has a boat at Humbug 2, and they're trying to get it out of there, but he's in jail, and the boat doesn't start and it doesn't float. So they want him out of there.
All right, look. All right, but you were told not to go there, right? Right?
Recently, yes.
Sir?
Yes.
Or July 7th, were you told that they did not want you there, and did they inform you that you were not to be on that property? Yes or no?
Okay. In confusion, I'm gonna have to say yes. In confusion, though, I was told not to be at the Gibraltar yard. They did not ask me not to go back to the Gibraltar 2 yard. I went to the Gibraltar 2-yard to ask them, where is my boat? May I please get my boat? And they said, when you come here, we were told to call the police. Well, we're not going to. And I said, no. When I came here, if you were told to call the police, then please call the police, because I don't want anyone else in trouble here but me. And so they called the police. All I was trying to.
Wait. How can we make arrangements for his boat to be released to him? I don't care if it's inoperable or not. He's in jail, obviously, but I hope they're not going to be charging him.
They're not charging him. They want to give him this money if you give him anything. Because he wanted to get a slip and they said, we're not doing any of that stuff. We just want to get him his boat off our property.
They have my money.
Mr. Bankovich, you're interrupting. Hang on. You're interrupting. Go ahead.
According to Mr. Bankovich, he's already posted all his bonds. He's just waiting for a tether. He should be out of there. He's already posted 10 days ago. So he's just waiting on a tether, so he should be out of there in the next few years.
When did you post your bond?
My bond wasn't being able to post until yesterday or 2 days ago, sir.
All right, so the only requirement now is that you be fitted with a tether, right?
Correct, sir.
All right. I don't want to make this bigger than it is.
I don't either, sir.
Oh, I know, but just stop interrupting me, will you please? I'm still a little confused. They did tell you, the owner, that they did not want you to go back to, before July 7th, true or false, to 28443 North Gibraltar.
True.
But you went back anyway, right?
I didn't know that they were both affiliated with the same address, sir.
Thank you, Rich. Just a yes or no to the judge's question. Did you go back after you were told not to?
Yes, sir. Yes, sir.
Were you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Plea is accepted.
Thank you, sir.
25G306532, 25G306489 is dismissed. That's a case in front of Judge Hessen. That's on motion of the prosecutor. I'm not going to order a pre-sentence report here, but I am going to release him on this case. I'm going to give you a $1,000 personal bond, and I'm going to set a sentence date. Now, I want to be clear. If you need to talk to anybody, you call Detective Robinson at Gibraltar if there's any problem with you getting your boat. Will you help him with that?
Your Honor, absolutely. I've already talked to Humbug, and I will be the one that facilitates the transfer to the boat.
You're not to enter. Again, I'm going to tell you one more time. You're not to enter 28443 North Gibraltar Road in Gibraltar.
Crystal
Not to
clear.
leave, hang on, just listen to me. You're not to leave the state without consent. You're not to violate a law. You must appear in court as directed. I'm going to set this for a sentencing, sir. And I want you, once you're released, Amy, I don't even know, the trespassing, that's 90-day misdemeanor. Is that printable? Is that something we can still get in the lien under these circumstances? I don't usually do it.
If it's a 90-day misdemeanor, then no.
Yeah, it's a 90-day under state law. All right. Yeah, so I can't, so there's no reason for me to order prints. I want to be clear with you. You're not to have any contact with any Humbug Marine employees, Humbug Marina employees. Now listen to me very carefully. I'm going to sentence you. If it comes to my attention that you've gone back there, I will give you 90 days on this. I'm telling you. Do we understand one another?
I do, sir. Yes, sir.
And you're not to possess any firearms or dangerous weapons, which is what I ordered on the other case. I'll give you a sentence date. I'm not ordering a pre-sentence. If you need to talk to Detective Robinson, you do that. I wouldn't recommend you talk to him in any way about the other case, but you talk to him about strictly getting your boat back. So you don't have somebody accusing you of getting a hold of Humbug indirectly or directly rather, and then me saying, well, you violated my bond and now we got a big deal. Okay?
Yes, sir.
Sentence date in about 3 weeks. You posted your bond 2 days ago or yesterday?
As far as I know, it was 2 days ago, sir. The day that I seen you in court, my brother had went and posted the bond.
And that was on, today's Thursday, that was Tuesday?
Yes, sir.
They gotta do a better job of getting people with tethers on over there. I mean, really, it's just like, seriously? Okay, August, what am I doing?
Judge, we can do 2 weeks or 4 weeks.
Let's
You're not
do
here in
4.
3
We'll
weeks.
do August 28th at what time?
8:30.
What do you want to talk about, Mr. Bankovich?
I can't make any money if I'm in here to.
I just got done telling you, I thought I did, maybe I didn't. I thought I said $1,000 personal bond. I'm going to release you in terms of this case.
Okay, yes, sir.
Mr. Bankovich, I have concerns here. I'm telling you, don't go near that property. Do you understand that?
Yes, sir.
And you're going to help him with his boat?
Absolutely.
Thank you. And if there's a problem, if they won't give you your boat back, then you come in and you file a handwritten motion and you come in front of me on that case. You can go through Mr. Gaith. All right?
Yes, sir.
Take me serious, Mr. Bankovich.
Yes,
Good
Your
luck.
Honor.
Thanks a lot. Thank you, guys. Thanks.
you.
All right. Let's take Kevin Joseph Connors. 252-645-760. Your appearance, counsel?
David Derrick on behalf of the defendant, Jay Connors.
Boy, am I disappointed Mr. Connors didn't come in. I really wanted to mess with him. Good. Go back and tell him I gave him 3 days on the court work program. To the charge of impeding traffic, which you're authorized to enter into that plea. True?
Yes.
Responsible or not responsible? He's got a clean record, 150. I'll give him till August 7th. Do say that to him. Judge gave you 3 days. I saw. Have a good day. Good to see you. Thank you. Again, tell Mr. Myers if you haven't, I said hello.
I will.
Dennis Lee Schmidt. 23T727-367. Mr. Gaith?
Good morning, Judge. Matthew Gates, on behalf of Mr. Schmidt. Please state your name for the record.
Pled the use of a controlled substance back on January 9 of 24.
Correct.
A violation was scheduled for April 11. He did not favor us with his presence. He then was here July 10th. He's got, and I want Elizabeth in here, please, Beth. He's got a 7-count violation. How's he going to proceed? Hey, can you mute the jail, please? Thanks.
It's my understanding that you'd already pled, would you serve the sentencing?
Well, Judge Kirsten wrote not guilty.
I have it down on the docket as a sentencing. I did ask.
Well, let's take the plea anyway, just to be safe, because Judge Kirsten wrote down, check the box, not guilty.
Correct.
And either he made a mistake, which I think is probably not likely. Yeah, he said arraignment for probation violation, not guilty, set hearing. So he has 7 counts. Is he going to be pleading guilty to all 7 counts?
Yes.
Is that what you want to do, sir?
Yeah.
If you plead guilty here, your 7411 status could be revoked, conviction entered, you'd be subject to a 1-year jail term. Do you understand that?
Yeah.
You didn't sign an advice of rights.
He does have one actually, Judge.
Can you hand it up, please? Did you read that and understand that?
Sir, I did everywhere.
If you plead guilty, you're giving up all those rights, and we're not going to have a hearing of any kind. Do you understand that?
Yep.
All right, as to count 1, to the charge, you failed to attend your scheduled probation visit on April 1 of 24. How do you plead?
Yep.
Count 2, that you failed to attend the court work program on 7 days on the court work program. How do you plead?
Yep.
Count 3, that you failed to pay fines and costs as ordered. How do you plead?
Yep.
Count 4, that you failed to submit the weekly testing as ordered. How do you plead?
Yep.
Count 5, you failed to provide proof of employment. How do you plead?
Yep.
Count 6, that you failed to provide verification of attending 12-step meetings twice per week after inpatient treatment. How do you plead?
Yep.
Count 7, that you failed to provide verification of attending and completing Intensive outpatient treatment, how do you plead?
I'm not sure, I did complete rehab,
I'm saying that you failed to provide verification as in charge of attending and completing intensive outpatient treatment.
To provide proof.
that's not what I'm about it. Yeah,
How do you, okay. Did you fail to provide proof of employment?
yes,
Did you fail to attend your scheduled probation visit on April 1st to 24?
Yep.
Did you fail to schedule and attend 7 days on the court work program?
yes,
Did you fail to pay fines and costs as ordered?
yes,
Fail to submit the weekly testing as ordered?
yes,
Did you fail to provide verification of attending 12-step meetings twice per week after inpatient treatment?
yes,
Did you fail to provide verification of attending and completing intensive outpatient treatment?
yes.
Anybody in the world force you to plead guilty?
No.
Anybody promise you anything?
No.
Please accept all 7 counts. I find them being made voluntarily and understandingly. Ms. Wilds, your name?
Elizabeth Wilds.
Did he go inpatient?
Your Honor, Mr. Schmidt never showed for his instructional. That show cause is all encompassing, where he did not show for his instructional. So on April 1st, he was scheduled to report into probation after his release from Oakdale, to get instructed on his terms and conditions of probation.
Do you have the screening report?
I do, Your Honor.
You didn't go inpatient either.
Yes, I did.
Where's your proof? Let's see your
No,
proof.
I didn't bring that, I didn't.
Why not?
Because I didn't realize I was supposed to. I had turned myself into the warrant last time. They said I was just coming here to, they didn't tell me they.
Slow down. Slow down.
They didn't tell me.
Slow down. Did you successfully complete inpatient treatment?
Yes, at Oakdale, I did. I
Good.
received a certificate. I had it at home.
And then what?
He became homeless.
Hang on. Go ahead.
In April of 2024, Mr. Schmidt became homeless and he did not have stable residence, Judge, until December of 2024. And this happened shortly after he left rehab. Judge, at the time, Mr. Schmidt did have 2 children, well, he does have 2 children that were with him, a 15-year-old and an 18-year-old. So he was in the process of trying to find somewhere to house his family, Judge, as well as he was out of his job and he had no money. Ultimately,
Well, because he was spending it all on opiates,
correct, Judge.
right? I mean, he's got fentanyl. He's got it all going on here.
Understood.
Fentanyl, coke, crack, hallucinogens, and him. I mean,
But he successfully did complete the rehab program, Judge, and at the time he was looking for employment. They ultimately ended up moving in with his wife's parents, his in-laws.
when?
In December of
So
2020.
for 8 months, 9 months, he went home. He was homeless with his kids and his wife.
The kids ended up moving in there first before me, and then I moved in December.
The kids and the wife moved in there, you mean?
Yeah, yeah. Shortly after.
When did they move in?
Instantly,
Well, then why didn't you move in?
because they didn't want me to, until I showed them some progress.
Well, that's good.
Ultimately, Judge, he does have employment now. He's been working, and he will be receiving his first paycheck tomorrow. So he is able to make, he is able to pay up his balance. He is able to afford to pay for the court work program, Judge, any fees that are associated with that. And he will be going to probation, Judge, to make any other arrangements.
Let me see the police report, please.
Yes, sure.
I mean, you had all right, crack pipes at Trenton High School falling out of your penis. Did you do anything after you went inpatient?
What do you mean?
Did you do anything? Did you get any kind of treatment? Did you go to AA? Do we have proof that you did anything since you've been out of inpatient treatment?
No, I've went to some NA meetings,
Don't-
but, no, I've been to some, I'm not saying I went
Okay,
every
let's
day.
see your proof of that.
I don't have proof of that, I went when I was living in the three courthouse.
How long was he inpatient, Mr.?
18 days or before I got the certificate, 19 days.
Any thoughts?
I don't have a lot of thoughts, Your Honor. As far as Mr. Schmidt's concerned, I mean, he had plenty of opportunity to communicate. An 18-day inpatient program is very small.
I ordered 3 months. I said 3
Yeah,
months.
I mean, I would, and, you know, we communicated with him by email, by mail. So if he was homeless from the address on Windsor, we did try to communicate with him by email as well. And at this point, you know, this February will be his 2-year marker at this point. February of 24, I think, is when he was placed on probation.
Judge, if I mean, Mr. Schmidt had no prior violations before these items. Obviously, he was going through some issues. Now that he says he's cleared up all his other issues and can focus on getting his life together, Judge, he's more than willing and able to comply with the court's order. We ask the court to give him an opportunity to do so.
At least I can prove myself to you guys, if I mess up, you can go ahead and throw the book at me, but let me show you that I can.
You did nothing.
I realized I did nothing, I
You did
was in a
nothing.
really bad area, but now I'm good, I got my head on straight, let me prove to you that I can do this, please.
Warrant was issued for your arrest 5 days before I sentenced you. I don't know if I was aware of it or not, for assault or assault and battery, and as far as I can tell, you haven't taken care of that yet, have you?
Well, when I looked at my name.
True or false?
The only thing when I looked up for my name, this is the only warrant I had. If I saw a second one, I would try to deal with that too. I'm trying to.
Amy, can you run his lien again?
Sure.
So we're gonna find out if you were lying to me or not.
Okay.
Because I show a warrant from November of 23 out of Dearborn Heights and another one from February of 24 out of Dearborn Heights.
If it wasn't online. This one was, that's how I found out that I had this one.
What'd you think? We threw the file in the garbage?
No, I didn't.
Well, come on. You got a big problem here, young man. I understand addictions. I understand drug problems. I get it. That's why we have a sobriety court and have had one. But you didn't get yourself any help. You went in for 18 days. That was, I wrote down twice a week after inpatient completed. And I said, you're to remain inpatient at Oakdale until released, having successfully completed inpatient, then to attend IOP and complete it. Did you walk out of there?
Got a ride, Uber to the third courthouse from up there.
How long were you? We will set this, you're gonna go talk to the lawyer now? All right, and I'm entering a not guilty plea, and then you'll come back after you talk to the probation order, which should be who? Hey, can you mute the jail, please? Thanks.
It's my understanding that you already.
Failed to submit the weekly testing as ordered.
Yes,
Did you fail to provide verification of attending 12-step meetings twice per week after inpatient treatment?
yes,
Did you fail to provide verification of attending and completing intensive outpatient treatment?
yes.
Anybody in the world force you to plead guilty?
No.
Anybody promise you anything?
No.
Please accept all 7 counts. I find them to be made voluntarily and understandingly. Ms. Wilds, your name?
Elizabeth Fleischer.
Did he go inpatient?
Your Honor, Mr. Schmidt never showed for his instructional. That show causes all encompassing, where he did not show for his instructional. So on April 1st, he was scheduled to report into probation after his release from Oakdale, to get instructed on his terms and conditions of probation.
Do you have the screening report?
I do, Your Honor.
You didn't go inpatient either.
Yes, I did.
Where's your proof? Let's see your proof.
I didn't bring that, I didn't.
Why not?
Because I didn't realize I was supposed to. I had turned myself into the warrant last time. They said I was just coming here to, they didn't tell me they did.
Slow down. Slow down.
They didn't tell me. they-
Slow down. Did you successfully complete inpatient treatment?
Yes, at Oakdale, I did. I
Good.
received your certificate. I had it at home.
And then what?
Judge, he became homeless.
Hang on, hang on.
Judge.
Go ahead.
In April of 2024, Mr. Schmidt became homeless and he did not have stable residence, Judge, until December of 2024. And this happened shortly after he left rehab. Judge, at the time, Mr. Schmidt did have 2 children, well, he does have 2 children that were with him, a 15-year-old and an 18-year-old. So he was in the process of trying to find somewhere to house his family, Judge, as well as he was out of a job and he had no money. Ultimately.
Well, because he was spending it all on opiates,
Correct, Judge.
right? I mean, he's got fentanyl. He's got it all going on here.
Understood.
Fentanyl, coke, crack, hallucinogens, and I mean,
But he successfully did complete the rehab program, Judge, and at the time he was looking for employment. They ultimately ended up moving in with his wife's parents, his in-laws,
when?
in December of
So
2020.
for 8 months, 9 months, he went home, he was homeless with his kids and his wife?
The kids ended up moving in there first before me, and then I moved in December.
The
So,
kids and the wife moved in there, you mean?
yeah, shortly after.
When did they move in?
Instantly,
Well, then why didn't you move in?
because they didn't want me to, until I showed some progress.
Well, that's good.
Ultimately, Judge, he does have employment now, he's been working, and he will be receiving his first paycheck tomorrow. So he is able to make, he is able to pay up his balance. He is able to afford to pay for the court work program, Judge, any fees that are associated with that. And he will be going to probation, Judge, to make any other arrangements.
Let me see the police report, please.
Yes, sure.
I mean, you had all right, crack pipes at Trenton High School falling out of your pants. Did you do anything after you went inpatient?
What do you mean?
Did you do anything? Did you get any kind of treatment? Did you go to AA? Do we have proof that you did anything since you've been out of inpatient treatment?
No, I've went to some NA meetings,
Don't-
but, no, I've been to some, I'm not saying. I went
Okay, let's
every
see
day.
your proof of that.
I don't have proof of that. I went with when I was living in the three-quarter house.
How long was he inpatient, Mr.?
18 days or before I got the certificate, 19 days.
Any thoughts?
I don't have a lot of thoughts, Your Honor. As far as Mr. Schmidt's concerned, I mean, he had plenty of opportunity to communicate. An 18-day inpatient program is very small.
I ordered 3 months. I said 3
Yeah,
months.
I mean, I would, and, you know, we communicated with him by email, by mail. So if he was homeless from the address on Windsor, we did try to communicate with him by email as well. And at this point, you know, this February will be his 2-year marker at this point. February of 24, I think, is when he was placed on probation.
Judge, if I may, Mr. Schmidt had no prior violations before these items. Obviously, he was going through some issues. Now that he says he's cleared up all his other issues and can focus on getting his life together, Judge, he's more than willing and able to comply with the court's order. We ask the court to give him an opportunity to do so.
At least I can prove myself to you guys. If I mess up again, go ahead and throw the book at me. But let me show you that I can.
You did nothing.
I realized I did nothing. I was in a really bad area, but now I'm good. I got my head on straight. Let me prove to you that I can do this, please.
Warrant was issued for your arrest 5 days before I sentenced you. I don't know if I was aware of it or not, for assault or assault and battery. And as far as I can tell, you haven't taken care of that yet, have you?
Well, when I looked at my name.
True or false?
The only thing when I looked up for my name, this is the only warrant I had. If I just saw a second one, I would try to deal with that too. I'm trying to.
Amy, can you run his lien again?
Sure.
So we're gonna find out if you were lying to me or not. Because I show a warrant from November of 23 out of Dearborn Heights and another one from February of 24 out of Dearborn Heights.
If it wasn't online. This one was. That's how I found out that I had this one.
What'd you think? We threw the file in the garbage?
No, I didn't.
Well, come on. You got a big problem here, young man. I understand addictions. I understand drug problems. I get it. That's why we have a sobriety court and have had one. But you didn't get yourself any help. You went in for 18 days. That was, I wrote down twice a week after inpatient completed. And I said, you're to remain inpatient at Oakdale until released, having successfully completed inpatient, then to attend IOP and complete it. Did you walk out of there?
Got a ride, Uber to the three-quarter house from Oakdale.
How long were you in the three-quarter house?
2 weeks until that was the free stay, and then I had no money to keep paying.
2 weeks, you said? I'm sorry, did I understand you correctly? 2 weeks?
Sorry, what?
Did you say 2 weeks you were in the three-quarters house?
Yep.
Where was that at?
Inkster and Cherry Hill.
What's the name of it?
I don't know, but this guy that owns Bush something, a landscaping company in Westland. It's right off of Ann Arbor Trail.
That narrows it down. You don't think I know who owns Bush Landscaping?
I just know he has a bunch of houses. I didn't know if it was in the court system, but you know what I mean.
Judge, Mr. Schmidt says if he tests today, he'll come up clean. So he's made some progress, Judge, I would argue. He did walk in on his own, so that shows some initiative for him to take care of his outstanding issues.
I know, but we do not have he doesn't have enough time here, in my view. I gave him 20 months. There's only 7 months left while I can have him on probation.
I think I'll make a dedicated effort to finish everything.
I'll do anything you ask me to do. I'm ready to keep on going.
June 11th, he walked in on warrant, but left before meeting with attorney or seeing judge.
The ride that I had to go.
What time did you walk in?
I think 10 o'clock, and no, 9:30, and we left at like 10:45.
Did you talk to a lawyer?
I didn't get to see anybody, I just sat there waiting. And then finally my ride was like, I gotta go, I was like, let's go. I came back as soon as I could. I was working under the table until I got a car, I'm driving out here. Now I gotta leave the job after that warrant got dropped. I'm trying to get everything dealt with. Trying to get out of the place I'm staying at, get my own place, bring my family. I can't do that in the jail cell.
Point 7411 status is revoked. Conviction entered. And I will sentence him right now. All right. All right, anything you want to say in addition?
I have no. Do you have?
My case,
Can I have another first page of the register? For a misdemeanor. Is there anything else that anybody'd like to say before I sentence him? I mean, yeah, just the first page. Misdemeanor. Mr. Dave, anything else?
I have nothing else, Judge. I would ask the court to consider, although the 7411 was revoked, Judge, I would ask the court to continue to keep Mr. Schmidt on probation. I believe that he is sincere when he says that he is dedicated to resolving these issues and carrying on fulfilling the conditions the court requests him to do. I don't know that at this point, Judge, jail would do anything more than just hinder his progress, because he does have a job. He's only been there 2 weeks. Steady employment, it's good money. He's in the process of getting some money together so he can move into an apartment with his family. So I think I would ask the court to consider maybe additional probation for the remainder of the time. And just that jail time would not serve, would not do anything to help his efforts.
So he spent 3 days in jail initially. Anything else? Ms. Wilds, do you have anything else? I know I asked you. There's nothing for you really to say here.
Yeah, I mean, I spoke with Mr. Schmidt on Zoom on the date of sentencing. He's well aware of, his obligations after treatment. Like I said, we reached out to him twice by mail, once by email. And I haven't heard from him from the time that I spoke with him on Zoom. So he's fully absconded. I know counsel said no prior violations, but of course there's no prior violations when you abscond. Yeah.
This is a new sentence. I just want everybody to be aware. So it's $100 fines, $500 costs, $600. I'm going to give you credit for 21 days served. I'm going to take you at your word on the inpatient. I'm going to order 51 days credit, 21 served, 30. You'll serve 314 more days if fines and costs are not paid. You can start to pay, I'm gonna give you some time to get your feet on the ground, so 50 a week you start paying beginning October the 10th, 50 per week beginning October the 10th. So you're gonna serve 30 days. And again, if you don't have the money to pay 50 per week beginning on October 10th, or you have that one, have the next one, don't have one, you call the court, we'll go on Zoom, or you can walk in here on or before the due date is 30, and I'll be glad to give you an extension. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yeah.
I wish you would have taken advantage of this. I really do. Good luck. People against Daniel Burton. Daniel Anthony Burton, 25F244060. Hang on 1 second on this.
Daniel Burton.
Beth, has he been in custody?
Yes.
So
It's the sentencing day today.
It was just a victim notifying, not a PSI was screening, and did contact her.
I see.
Because we weren't aware
I
that he was
see.
coming in, but she did speak with the victim. And she left details on the voicemail, and she even faxed the letter over to them.
And they didn't respond.
Exactly.
Is the victim, is there anybody here from Walnut Creek Apartments here? Walnut Creek Apartments here? Anybody? All right. So he pled in front of me back on June the 5th, actually in front of Judge Hessen, and then we set it for sentence, failed to appear June 26th. Then a bench warrant was issued, and then he was arraigned on July 28th by Judge Hessen. And this was set for sentencing today. Want to say anything?
Well, I will, Your Honor. My client realizes the error in his decision that particular evening. He went to go see his child who he hadn't seen in at least 6 months. His mother refused to allow him to have any contact with the child. He knew he was trespassed at the time. We've taken the time to talk, and he understands that there is a proper legal route to resolve that circumstance. I told him you need to go to family court. You get that worked out, get some official parenting time, so forth and so on. He understands that. He really understood during his time since he's been incarcerated, there was a better way. So I made sure he understands there's an option to not be put in this situation in the future. He does not plan to be in this situation ever again, Your Honor. He's learned from this. My client's been in jail now about 5-6 days.
He's also got about 14 warrants out for him. You don't show up in court.
Well, Your Honor, my understanding is, from talking to my client, is that he has been steadily taking care of these matters. He's in the process of that. There's some outstanding.
This was run July 28th.
Well, again, Your Honor, he's in the process. He knows there's still some matters he needs to clear up. He's a young man. He's 25. He knows he's made some mistakes, but he's tired of going through this process, Your Honor. I'm hoping that the court will take that consideration here in sentencing.
Scale of 1 to 10, your respect for the system is a negative 7,816. I don't know who you think you are. I don't know who you think you are. I don't understand this. You don't show up for court.
Okay. I live in Livonia. I don't have means of transportation. I don't have a vehicle. Typically, I drive a bike or I use the bus. Due to the fact that this courthouse is in Woodhaven, there is no active bus line for me to reach my location. I do have outstanding warrants. 90% of them are first item. I don't drive anymore.
You know what?
This is my last
Good.
court case or active warrant for Flat Rock, or I should say even this district in general. I'm working at one city at a time. Currently, I'm working on Flat Rock. My family's leaving from this area, so I should too.
I'm talking
I made
about
a mistake, and
mistakes are one thing. Not showing up in court is another. I want you to think about what you just told me. I know there's this big prevailing attitude now that let's do everything by Zoom. Then people don't have to get rides. They don't have to walk. They don't have to take a bicycle. I get it. I've said this to my closest friends multiple times, and I will say it to you, Mr. Burton. There's only one of three ways you come in here to this courthouse. There's 7 cities and townships. You either live here, you drove here, or you got a ride here. It's the only way. Unless you're taking a helicopter or something, I don't know. There's only one of 3 ways you can make it into this jurisdiction in front of judges here. And I love when I hear that, because it's like, really, you could get here to commit the crime, but now you can't get a ride to come and go to court. You were just here. This incident just happened back on May 29th. You were in this jurisdiction. How'd you get here?
I rode a bike.
You rode a bike from Livonia to Walnut Creek Apartments?
Correct.
Well, then you could have ridden a bike to get here for court.
Also, there was a little bit of confusion because I had another case with Flat Rock. I thought everything, once I was completed with probation, I didn't fully understand that I had another trespass.
Son, I just want you to think about what I said. This is a trespass. This is not the biggest case I'm going to see in the next 20 minutes. I just want you to think about what you're saying and what you're doing here.
I understand I need to take responsibility for my actions.
And it didn't sound like you did. Where were you working?
Well, I did have a really good job. Actually, I was supposed
Where?
to start on Monday.
Wait a minute.
As a distribution.
We're supposed to start Monday?
Yeah, but
Everybody's starting work when they get put in jail. I was supposed to start a job that day. Where?
it's in Melvindale.
What's the name of it?
And it's distribution.
If I get on who'd you deal with? Who hired you? What was his name?
It was the security guard.
A security guard. What's his name?
Her name was Miss Oldman.
They're gonna hire you in security?
Yes.
So if I get on the phone right now and I call Ms. Oakman at that location, you're telling me she's gonna verify that you were supposed to start a job on Monday?
If you can contact her, it's a U.S. import plant. So it's very difficult.
There's nowhere for them to look at that.
Hey, I need you to mute. Thank you.
The bottom line is, if you recall, she would verify that you were
Yes.
in some job.
Is this the only case he's in custody on?
That's my understanding, Your Honor.
I mean,
But I suggest the court sentence him to 7 days jail time. So you've been in jail for 7 days. You have time to think about it. It's not that it's,
I could promise you now that I will not be returning back to Flat Rock.
what day were you picked up on the warrant? Judge Hessen arraigned you
Sunday.
on Monday.
so.
Well, that's not 7 days. That's 5 days, right?
Well, the original charge, he was in custody, I think, for a couple of days when he got arrested on this matter. It was at least 2 days there, so I understand.
Mr. Burton, anything else?
No, Your Honor.
Did you graduate?
Yes.
Well, you hesitated. You either did or didn't. If you didn't, you just be honest with me. I'm telling you, you didn't.
No, I didn't graduate.
Well, then why'd you tell me you did?
I don't know, I just feel better for the case.
I know, you can tell the judge whatever you want, and you think the judge will buy it.
Well, Your Honor, I think my client might be a little embarrassed about that fact.
Oh, come on. I mean, listen, I know what you're doing here. You're doing a great job. I love working with you, or having you representing these individuals. But come on, I mean, I can let a lot go, but I think I want to call Ms. Oakland. Do you have a phone
Her
number?
number.
Pardon?
I don't even know her number.
You weren't going to get a job there, were you?
I had to appear in person on Monday.
Sir, you didn't get hired there, did you? You were going to get an interview, right?
Correct.
Well, then why'd you tell me you got hired if you were just getting interviewed?
It was almost certain that I was gonna be working there.
Who told you that?
The security guards themselves, I just needed to show up to the interview.
I can't justify keeping you in jail. Listen to me very carefully. This is the beauty of the system. And I don't care if you're in this courtroom or down the hall or in any courtroom. We have a sense of fairness about us. And sir, that is the only thing that's going to save you here. Because I cannot rationalize putting in somebody in jail for longer because they were going over, even in violation of a do not enter this property order, to go visit their child. If you come back on it again, you're going to have a massive problem with me. Do you understand?
Yes, Your Honor.
I'll give you a chance. 200 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 40 in attorney fees. Your total's $565. 12 days jail, credit 7. I'll let you serve the other 5 days to community service. And I'm going to give you all the way until September 30 to complete 40 hours of community service to satisfy that. I do not expect you to go back to Walnut Creek Apartments. Do we understand one another?
Yes.
You are very lucky that I need to go home and look myself in the mirror. And I'm not going to be overly harsh with you, even though you probably, for the whole segment here, deserve that. I'm going to let you pay this at the rate of $30 per week. And I'm going to start this beginning on September the 5th. You understand?
Yes.
If you don't have the money, you call the court, we'll go on Zoom. Look, I don't think you're coming back, but I'm telling you, if you don't, you're going to serve the remaining, when you come in on the warrant, you are going to serve the remaining time in jail. Do you understand that? And that remaining time in jail will be an additional 78 days. Do we understand one another?
Yes.
That's if you don't do your community service or pay your fines. You understand that?
Okay.
Do you understand that?
Yes, I understand.
Bert, Mr. Bert, time to grow up. Time to grow up. Good luck.
Thank you.
Christian Bush.
Right here.
25T645623. Sorry to keep you waiting on this.
You're all right, Judge. I've got a 10-30 minute down the hall, so
Okay,
it's all good.
all right, your
Your Honor, for
name,
the record, James Sparrow, P57197, on behalf of Mr. Bush in this matter.
sir, your name?
Christian Bush.
All right, so you're gonna plead to, he's gonna plead to impeding with the disobeyed police officer directing traffic charge to be dismissed, true?
That is correct, Your Honor.
Is that what you want to do, sir?
Yes, sir.
You didn't sound convinced.
Your Honor, he, per the prosecutor's suggestion.
I know, I don't like that, but he sent him to a traffic course.
He took a driving safety course, and there was a very similar scenario in the course where my client did pretty much exactly what he did here. I think this is a resolution that not everybody is perfectly thrilled with, which means it's probably the right resolution.
To the charge impeding traffic, responsible or not responsible?
Responsible.
All right, I'll accept the plea. $200. You go down and take care of that. You're all
Your Honor,
set.
could he have 2 weeks? His car broke down
I don't
2
have a
days
problem.
ago.
That's fine.
Thank you, Your Honor.
We'll make it August the 15th. That's 2 weeks from Friday, okay?
I appreciate it.
Best of luck to you. Nice to see you, Mr. Sparrow.
Very good.
Jim Construction Services LLC. 25T645896A, B, and C.
Good morning, Your Honor.
How you doing?
How you doing?
Good, you? I told you you needed a lawyer. Did I not tell you that?
No, I wasn't aware of that. No, I was not aware.
What's your name?
Carlos.
Carlos what?
Henry.
Listen, I told Mr. Garcia, Carlos Pena, is it Carlospena?
Yeah, no, P-I-N-O-N.
Pinon?
Yeah. I wasn't aware of it.
Slow down. Slow down. Somebody showed up here, Gerardo Garcia, July 17th.
Yeah, that's my cousin. We just run the company.
Slow down.
So.
Slow down. Let me talk. You know what I told him? He was a foreman, right?
Yeah.
I said your company needs an attorney. You can't keep showing up here without an attorney. I can't let a corporation be represented by a foreman or anybody else on a misdemeanor. I just can't do it. Didn't he tell you that?
No, he didn't.
Well, maybe you should get another partner. If he's not telling you that, he's not conveying other important things to you. I told him that. I made that clear.
I just see the paperwork on my desk and,
He didn't bother telling you that.
no, he didn't. I'm so sorry he did not.
Wow. What's your position with the company?
I'm a manager. I take care of all the.
Who's the principal of the corporation, the president?
The owner would be his father, Gerardo Garcia's father. He's going through colon cancer at the moment. He's in the hospital.
Yeah, but he can't appear. You guys gotta hire a lawyer. I'm gonna tell you one last time, and then I'm gonna start show causing people.
So I can just, any lawyer does not matter, and
You gotta have a lawyer represent the corporation. I can bend the rules slightly on a civil infraction where there's a resolution. I can't do it on a misdemeanor. I mean, this is not new. I'm not picking on you guys. I've been doing this.
I understand completely.
Well, why didn't he tell you? Look, I'm gonna adjourn the arraignment and pretrial one last time.
Thank you, Your Honor. Thank you.
Defendant needs lawyer.
Understood.
All right?
Yes, sir.
August 14th, Amy,
Yep, the 14th at 9:30.
at 9:30.
I'm so sorry.
You seem like a nice kid, but so did he. Don't let me down because I'm not gonna be nice about it next time.
Things going on. Thank you.
Good luck. Go down the hall. They'll give you a notice.
Thank you.
Napoleon Chevalier Robinson. Come on in if you would, Mr. Gates. 24F2433037, assuming this is yours. Did you speak to Mr. Gates, Mr. Robinson?
Yes, sir.
Or was it Mr. Shemke?
Well, I spoke with the attorney.
Yeah, we got a bunch of lawyers here. Did he go speak to Shemke or Gates?
I can't remember. I gotta look.
What's that?
The attorney's name was Mr. Shin.
Oh. Yeah, we'll need Mr. Shemke, 227. I got him. Why don't you have a seat right behind you? 1 second. Yep.
Yes, for sure.
I need you on Robinson. Did you talk to him?
Yes, I did. I'll be right in, John.
Perfect. Randy Allen Harper, 25T645535.
Good morning, Your Honor.
Good morning to you. Boy, I don't know how they give these deals. I wish I was a lawyer again.
Good morning, Judge.
You got this guy, you got him no ops from revoked?
Yes, Your Honor, I do have an explanation.
I can't wait to hear. He's gonna plead to no ops, the revoked to be dismissed.
Yes, Mr. Shemke, very good.
How long's he been revoked?
Your Honor, it's been revoked for a little while, Judge.
Yeah, I know. How long?
I don't have the exact amount of time,
And then he picked up another one
which I did handle, Judge.
in February.
Correct,
And he's
Judge.
driving on a revoked?
I took care of that one as well, Judge.
He's gonna plead the no operator's license on person?
Yes, Judge, we've started the process of actually getting his license back. We're already starting to work on the letters. He understands he has to get a substance abuse evaluation as well as
All
drug
right.
testing.
Okay. If you plead to no ops, I'm gonna dismiss the suspend, revoke, denied. I try not to get involved in what they're doing. That's punishable by up to 100 fines, 90 days jail, costs or all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
I appreciate that as well, sir.
All right. You, just for further information, I believe from looking at his record, He was revoked back in 2000, and then he picked up another drunk driving while he was revoked and pled to a felony, right?
Yes, I handled that one as well, Judge.
You understand everything? Yes? You understand your rights?
Yes, I
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
I do, sir.
You're charged no operator's license on person. How do you plead?
Guilty.
Were you operating a motor vehicle in Fort or Sibley and Trenton, May 15 of 25 at 9:39 p.m.?
I was.
Did you have a valid license? You were revoked, true?
Yes, sir.
Are you on probation?
No.
Parole?
No.
Anybody forced you to plead guilty?
No.
When was he sentenced on that?
He'll be sentenced, coming up in August.
You got your waiting sentencing on a felony. I'm just telling you, I don't mean to be, I'll accept the plea. You're waiting sentencing on a felony and you go out and violate your bond by driving on a revoked license again.
We had to have a dialogue regarding that, Judge, because, he was trying to work to make extra money, and I explained to him that, listen, you're.
Where does he work?
I'm a union carpenter, I do the Detroit auto.
Sir, you can't do this.
No, I know, I understand. And he's accompanied by his wife today. We had a long heart-to-heart that, he's working actually against what I was trying to accomplish in the circuit court, so he's off the road, Judge.
Is there a sentence agreement on that?
Yes, Judge, right now, I got it reduced, and, he is looking at 60 days Wayne County Jail.
To OWI 2?
I actually got the operating influence kit completely.
What in the world's going on? Why was that? Was it a good defense? I hope.
It was a good defense attorney. My wife.
What was the plea to? I'm curious.
Judge, I believe that we got it down to a 7411 possession charge, dismissal of the operating under the influence, dismissal of the driving.
Possession of what? What kind of drug?
I don't recall offhand what
kind of drug?
was in the other case. Oh, cocaine. Was it mine? Yeah, stop.
He's been driving all over. I mean, you've been driving all over. You had a violation of the basic speed law here in January. You had a February speeding out of Taylor. You went there and took care of that shortly after you took care of your drunk driving, at least the plea. Then he gets in another crash in June of 25. I mean, you're going to set a record for what I've done on no ops. You know that?
Judge, I'm confident I won't ask for anything for about a year or so.
What's that?
I said I won't ask for any other requests to the court regarding no ops for a period of time.
Well, no. Listen, this one is one of the worst ones. I mean, it just is. He's still driving around, acts like he owns the road. He's drunk. He's got cocaine. They get it reduced, and he's not even taking advantage of a good plea deal that you got him. I mean, there's no end in sight for him. Does his wife drive?
Yes.
Why doesn't she drive him to work?
Your Honor, we made the necessary arrangements regarding that, obviously past mistakes and past bad judgment, setting aside he understands that going forward, I mean, he's gonna have to vote for him.
Anything else?
No, Judge.
Sir, is there anything else that you'd like to say?
No, sir.
I can say this because you're significantly younger than me. I don't normally order people at my age or your age to go on the court work program, but that's exactly what you can do. If you can be a carpenter. I mean, I can't look at myself in the mirror and send somebody to jail on no ops. And that's what the conviction's for. 100 fines, 300 costs, 75 victim's rights fee, $50 justice assessment. When I said I was going to set a record, it's about as bad as I've done to somebody pleading to no ops. 5 days court work program, $175 in court work program fees. So you got 5 1/4. That's 100 fines, 300 costs, 75 victims' rights, $50 justice assessment, plus 5 days on the court work program. There's $170 in court work program. I'm sorry, $175 in court work program fees. Your total here with everything amounts to $700, 5 days court work or 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you well. He can pay that now.
You already can make a payment tomorrow. We're gonna ask for a payment.
How much?
I think I make a $200 payment tomorrow.
And then what?
Maybe you make payments every 2 weeks.
I'll let you pay $100 per week. You will start that beginning on Monday, August the 4th. Your lawyer did a great job for you, Mr. Harper. I have a feeling your luck's gonna run out if you keep acting like this. Take it however you want to take it. You have to meet with probation to set up your court work program days. Good luck. Napoleon Chevalier Robinson.
Yes, sir.
24F243037. Your name, sir?
My name is Napoleon Chevalier Roberts.
Need Jessica.
Your Honor, actually, can we get this matter passed? I need to actually ask for a couple.
Yeah, I need a 5-minute recess after that last one.
Thank you.
I mean, I'm not blaming you, Mr. Shemke, at all.
I
Good luck. Stay seated, everyone.
Thank you. And the court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder to the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the cases of the people of the state of Michigan versus Christopher Nutley.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Nunley. Mr. Nunley, will you please state your name for the record?
Christopher Nutley. Thank you, sir.
Your Honor, we are asking that these matters be set for a preliminary exam.
All right, all discoveries complete.
Yes, Judge.
People have their witnesses available to 12.
That's fine.
All right.
Judge, is that enough time? I'm sorry, for a writ to be done? He is,
He is. Yeah.
Jackson.
Preliminary examination in person, August 19, 2025, 9 a.m. That is before. Actually, it's at 12 p.m. before me.
Thank you, Judge.
Thank you. Bond will continue. Okay. Let's call the case of the people versus Jacqueline Jones, Washington.
Andrew Childers appearing on behalf of the people.
Malika Fatima appearing on behalf of Jacqueline Jones, Washington.
Washington, Jones, can you state your name, please?
Jacqueline Jones, Washington.
Thank you.
Has the court received the report, competency report?
Is this a competency? Yes. All right. I have the report finding that the defendant is not competent to stand trial.
Yes,
Is that
we've
the
sent an
only?
order.
Pardon?
We've sent an order finding her incompetent.
Is there any other evidence?
On behalf of people, Your Honor, the report does says a competent but likely to regain competency in the statutory period.
Say that last part again.
I believe the report references the CFP is seeking time for treatment and they miss Jones, Washington can be restored.
They didn't put that in the front of the report.
At the end of the report.
I'm sorry.
It's at the end of the report.
Yes, okay, I see it. Very last one, I see it. She can be restored in the statutory time frame. All right. You said you sent orders in.
Yes, we have.
I do not have them, but what I will indicate is we will set a competency hearing on this deal. I need 90.
October 23rd.
Set a review in this matter October 23rd, 2025, 9 a.m. Bond will continue.
We need to by case only.
Your Honor, if I may, we need an order on the 2025 case only.
Yeah, because it's separated from the other ones.
Got it.
Was there an order sent back in May, I thought? The court doesn't have that?
Which order? Are you talking about the order on the findings? Not the finding, but we need the. Ms. Wilding?
I'm sorry, the 2025 case, there was an issue with the timing of it, so.
Correct.
The 2025 case, so that's the one that needs the order.
Okay. So, okay.
Got it.
Good, good. Okay.
Got it.
So it's the 25 case that needs an order.
Yes.
Okay.
Thank you. Court does call the case. People versus Madden Delaney.
Your Honor, good morning. Joe Simon on behalf of Mr. Delaney.
Madam Delaney?
Go ahead, sir.
Your Honor, I made a proposal to Mr. Banis. Mr. Banis wants to have the opportunity to talk to the officers about the proposal I made. Wasn't able to make that happen by today. So where the parties are requesting an adjournment of the PCC.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case. People versus Keandre Allen.
And we send on behalf of the people, Your Honor.
Robert J. Cole on behalf of Mr. Allen.
Your name, sir?
Keandre Allen. Thank you. Judge, I saw Keandre last night. He wants to proceed to exam. We have the discovery.
Your Honor, I did respond when appropriate.
All right. You said discovery is complete, Mr. Phillips.
Yes, Your Honor, 99% of it. We will get the phone calls this week.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m.
Judge,
That's before.
I'm sorry, I didn't mean to interrupt, but I have a circuit court trial starting on the 11th. Can we bump it past that?
August 19th, 2025, that's at 9. At 9 a.m. before Judge Moore. As to bond.
Your Honor, this is my attention that since you've been arraigned, I haven't had a chance to listen to all the calls. I have 7 calls from victims. One of the calls I know for sure. Victims listed on my report, and he mentioned his kind of contempt. Judge Washington's court. So this time I'll be asking you to go for the police for your vote.
Any response?
Judge, I spoke to my client last night. Assured me he has not made any calls. I would just ask you to allow him to continue.
That he's not made any calls?
Correct. Is that correct? Pardon me?
Correct. Right.
Not to the victim, Your Honor. There's obviously been phone calls, but not to the victim.
Okay, were phone calls made to the victim's number?
No, Your Honor.
Our numbers restricted. You're saying they were?
I have phone
They're
calls
restricted on
on his court, and he mentions his hold on Judge Washington's court.
So do you want me to listen to that? Because if I do, then not only would I revoke his phone privileges, but I will revoke his bond. And I find out
Judge,
what he's telling me not to be the case.
Just cancel the phone calls for now, Judge.
Defendant's phone privileges are hereby revoked, and I've signed that order. Bond in all other respects will continue. Thank you.
Thank you, Judge.
Court does call the case of the people versus Conrad Neary.
Good morning, Your Honor. Victoria Burton here, Assistant Prosecutor here on behalf of the people.
Your Honor, good morning again. Joe Simon on behalf of Mr. Neary. State your name, Conrad. Conrad Neary. You don't have to wait. Just half step forward.
All right, go ahead.
We've reached a resolution, Your Honor. You should have both a plea sheet and an executed advice of rights form.
I do. Plea form indicates that the defendant will be pleading to an added count 3 of use of cocaine, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 in this case will be dismissed. He's also agrees to plead guilty under 7411 and continue compliance with his recommended treatment as part of this agreement. Also, the prosecutor will recommend no upfront jail so long as continued compliance with recommended treatment while on probation. That's the court's full understanding of the agreement.
That's ours as well, Your Honor. Mr. Neary filled out an advice of rights form. He's ready to answer your inquiries, and I'm pretty sure the matter's remanded to Your Honor, which is why there's no sentencing judge waiver on it.
That is correct.
Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Conrad Neary.
He's pleading guilty.
Yes.
Is that correct? Okay. Because I have it before. All right. Sir, it is this court's understanding that you are pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay, yes, yes.
You
I
understand that?
understand, I understand.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
To another court. You're not on.
No, I'm not. No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes, Your Honor.
December 9th, 2024, at I-94 near South State Street in Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
It was for your personal use.
Yeah, it was for my personal use.
Okay, and you knew what you had was cocaine, is that correct?
Yes.
All right, sir, I do have to advise you that if between the time of my taking your plea and accepting your plea, you commit misconduct as defined by the Michigan court rules between this time and the time of sentencing, that first of all, you would not be permitted to withdraw your plea. You understand that?
I understand.
And you also understand that the court would no longer be bound by any type of agreement or evaluation of your case.
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Defense is not.
No.
She was concentrating. And have I complied with the court rule? It would be proper to accept this defendant's plea.
So satisfied.
Yes, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 27th at 12 p.m.
August 27, 2005, 12 noon, before me.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. Wait with your mom right out front.
Court calls the cases of the people versus Todd Rayberg.
Send in for Jay. Yeah. Oh, yeah, sorry. Yeah. Easy. I didn't know. You already do. Okay. I'm not.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rayburg.
Kyle Burrell with and on behalf of Mr. Rayberg in the case ending in 0891.
Assistant Public Defender Jay Bellinger on all cases not ending in 0891, Your Honor.
All right. Your Honor, so Mr. Rayberg has a number of other matters pending. So at this time, we are asking for an adjournment to allow everything to sort of catch up.
Yes, Your Honor, we have all the orders signed for his cases today. I understand there may be some cases pending, but as of today, we are just waiting on a bed availability for him.
All right, so you're asking for the adjournment also?
An adjournment also, Your Honor.
All right. You're looking for at least 3 weeks? Is that?
Yes, Your Honor.
All right. Probable cause conference in these will be adjourned to August 19th, 2025, 9 a.m. All right, that's a Tuesday, just short of a 3-week time frame.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the people versus Seth Priester.
Okay, originally, the people for the people on this and on the cases as well.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
And Judge, not that anyone asked, but I'm the co-defendant's attorney, Mr. Henning. Just in case I'm needed, I'm here. Good morning.
You kind of snuck up there.
I did, yeah. A little shorter today.
How come you didn't do something? No, it was a threat to me.
Definitely a threat.
Do we have this?
We don't have a defendant.
Well, what are we doing on Mr. Priester's case? And the other case, I guess we'll bring him out, but
Well, with regards to my case, I think Mr. Priester's case, I think we were ready to set for exam.
We were requesting an examination.
all right. Is everybody going to be ready to go on the 12th?
The 12th is okay. That works with Ms. Barnwell.
One
What
split
day?
second, Judge. One split
Why
second.
does,
I'm trying to.
when this case is called, it takes so long? Not looking at who might be the problem. No. No, it's okay. I guess.
Okay. You said the 12th? One split second. Oh. What do you know? The 12th is available. I'm available on the 12th. Thank you. So happy.
So in the Priester matter, until Mr. Henning gets out here, preliminary examination in this matter will be in person. It will be set August 12th, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue. And hold on one more. Who do we have? You have Henning? Court calls the case of the people versus Henning.
And Christina Costantino on behalf of Mr. Henning, if I didn't already put that appearance on. Mr. Henning.
Sir.
Mr. Henning.
Sir.
Devassia Henning.
Thank you. All right, and in this matter, your house, you have indicated requesting a preliminary examination, discovery is complete.
Yes, Judge.
People could have their witnesses, available on that date. I can set preliminary examination in this matter for August 12th, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue. Thank you.
Thank you, Judge. Would the court perhaps hear just a very brief bond argument? I'm just asking for a 10%
200
provision.
cases I have today. Go ahead. I'd love to hear it. Go
I'm
ahead.
sorry, Judge. We're just asking if the court would at all consider a 10% provision of Mr. Henning's bond. He is obviously unable to post the bond where it's currently set. He has been incarcerated now for about 3 months. He has made the very most of his time incarcerated that he could. He's completed his GED at the Washtenaw County Jail, which is not a small feat by any means. He did that within the quickest time that it's even possible to do that. He very much wants to use his new GED to obtain employment upon release. He has wonderful family support. His family's present in the courtroom. They've been present at all court dates. I know that they'll be present in his life if he is to be released. We would ask if the court would consider a 10% provision in his bond.
Response. What was the weapon?
Firearm.
I'm gonna let what I'm gonna do at this time is I'm not gonna give it 10% provision. I think his, well, that would be 25,000. I presume, Ms. Barnwell, you're also making
Yes,
that same-
Judge. Yes, Judge, my client is, he's been very compliant while he's being placed at the juvenile facility in the compound there. His mother wants a tether, and I think that would be appropriate.
his bond is set at $250,000 at your client, Ms. Barnwell. Can I have that file back?
Yeah, that is excessive, Judge. I know that this court is aware of the presumption of innocence. And that it's not just a phrase.
Really? Didn't know. In both of these cases, I'm going to modify their bonds. There is a provision that if they're released, they are to go on tether. That will remain in effect. I will reduce the bond to 250,000. I'll give a 10% privilege on that.
And Judge, my client's bond, I believe, was 100,000. It was originally set at, or maybe it was originally set at 250, but it was at 100,000.
What do you have as bond? Well, what I'll do is if it's 100,000, I'm not going to get the 10% privilege on the 100,000. I'll give it on the 250,000.
Okay, Judge. Yes, we would appreciate that. Thank you.
All right. Thank you.
Thank you.
The court does call the case People versus Sherry Walker.
Yes, Your Honor, please do not report Brandon Bird on behalf of Sherry Walker.
Sherry Ann Walker. What are we doing?
I'm just asking, you should have an adjournment.
I did. All right. Probable cause conference in this matter will be adjourned August 14th, 2025, 9 a.m. Bond continued.
Thank you. You and your Honor, the court have a great day.
Court calls case of the People versus Mary Collins.
Howard, on behalf of Mary Collins, who's at the podium.
Thank you.
Ms. Collins, please introduce yourself to the court. To the podium.
Good morning. I'm Mary Collins.
Your Honor, so today's a date and time set for probable cause conference. We are working on getting some mitigation documents to the prosecutor that may take a little bit of time, so we're just asking for an adjournment.
You say it may take a little bit of time. What are you talking about?
3 weeks probably would be, you think, could be what we talked about?
August 19th, 2025.
Thank you, Judge.
And bond continued.
We don't know.
Thank you.
Court calls case People versus Oreska Dennis. Back.
I'm back, Judge. Christina Costantino appearing on behalf of Mr. Haruska Dennis, case number ending in 1150.
Malika Fatima appearing on behalf of Haruska Dennis on the other cases.
All right.
Mr. Haruska Dennis, could you state your name for the court?
Zachary Haruska Dennis, Your Honor.
What are
Good afternoon, Your Honor. Amy Reiser appearing on behalf of the people.
All right. And what are we doing?
Judge, this is the date and time set for PCC. We would be asking to have this matter set for an exam. I believe that discovery is complete.
The same would be for us. We would like to set this matter for preliminary exam.
People have their witnesses available to 12? Yes. Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Judge.
Cases of the people versus Anthony Alfaro Callejas.
Good morning, Your Honor. Zach Bonham on behalf of the defendant who's joining us by Zoom.
Good morning.
Sir, can you please state your name?
Anthony Alfaro Callejas.
All right. What are we doing today on these?
Your Honor, we're
My counsel reached out, we have a discovery, technical issue that we're trying to resolve, so I'm gonna put down what has entertained. I believe, we are requesting an adjournment. I did extend an offer, which he has, discussed with his client, and they're still considering that as well.
That is correct, Your Honor. We're waiting on a little bit of discovery left over. We would ask for this to be reset. And also, when we're done, I'd like to make an amendment to the bond that you granted at the last hearing.
Probable cause conference, August 14, 2025, 9 a.m. As to bond.
Your Honor, you granted home confinement at the last hearing. My client has went to that location. It is quite a distance from where he's working. He has a friend that lives much closer to where he works. I think it's about 15 minutes away. It's a walk for him. I provided an amended bond order that I sent over to your office, also to the prosecutor's office, so they could see that as well. There's the new address of, I believe it is 4822 Washington Avenue, Unit 15, Ann Arbor, Michigan, 48108. So we just ask that you would amend the bond to allow him to reside at that address for work purposes.
Any objection?
Okay.
All right, I will sign your order on that, counsel.
Thank you, Your Honor.
All right, thank you. Bond will continue in all other respects.
Thank you. Have a nice day.
All right, you too. Hold on now. Court does call the case, people versus Marvin Sullivan.
People.
Morning, Your Honor. Michael Vincent on behalf of Andrew Sullivan. Hey, good morning.
Your name, sir?
Mark Sullivan.
All right. Good morning, Mr. Vincent.
Good morning, Your Honor.
You're requesting an adjournment?
Yes.
Who's, oh, somebody's here with you. Good. How much time did you need?
A lot. Just for the court's information, over the night, we received 700 pages of a report. And more to, I believe we're picking up even more information from this field. My comment would be cooperative with discovery. The court should know that.
I can, the 19th, which is a Tuesday, or the following week, 28th, which any objection from the people?
Okay.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond in this case will continue. Court does call the case of people versus Amar Amadou. Amar Amadou? Who's on this? Shocking, it's canon. Come on. Welcome.
Thank you, Your Honor.
No. That was wrong. That was wrong on.
I messed up. Okay. Stephanie Cannon, on behalf of Mr. Ahmed, to keep your hands out your pocket. Your Honor, Your Honor, I am going to ask for an adjournment, and I will.
Are you?
Yes, a 2-week
Took you
adjournment.
that long to
case.
decide?
I had to discuss something with my client, Your Honor, that's
just
all.
did that now?
Yes.
Okay.
Yes, that's the thing, yes.
How much time did you need?
I'm requesting a 2-week adjournment.
Are you?
Yes, please.
I bet you I don't have a green sheet.
You do not,
You are
Your
looking all around for one. One's not gonna magically appear. We'll wait. Not long. August
I'll do one, Your
14th,
Honor.
2025, 9 a.m. Bond will continue. That's okay. Mr. Brown was filling one out for you, but
I appreciate it. I will get done, Your Honor.
thank you. They're bringing more? We don't have enough? What? Court calls the case of the people versus Mario Amison.
Alexander on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amison, is approaching the podium. Amison, please state your name for the record. Mario. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address the problem, feel free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Fleischer. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What, 100 times?
100 times.
Okay.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
Kidding. My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me, can I talk, man?
What do you want to say?
She came to visit me, man. They let her come to visit me, so it couldn't have been that serious of a non-contact.
So, you know, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and in the.
Domestic violence or nothing, man. It's fraud.
Yes, we got it. You know, it's my understanding that the complaining witness has reached out to him several times, and so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. And so, you know, so that at this point we are.
Let me ask this then. Other than those times where the defendant alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor.
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there and.
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. She able to visit me if it's a no contact order, and I'm in jail.
That I don't know, and that's why I asked if I'm trying not to take those contexts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that.
Then they
So
took,
then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
right. I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir.
Like,
I don't.
Because they telling you half the story, man.
I'm not gonna get that information right now. I'm not supposed to have that information right now. Anything else, Mr. Anything else, Mr. Bedell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. Defendant's phone privileges at this time are revoked. You can make the argument before Judge Fleischer to reinstate them after the preliminary examination. Thank you.
You fired, man.
What'd you say?
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. Let's go. I'm gonna pick up the next one and just. This is on your advice, because I got something to say. But I'm not going to. Court calls the case, People versus Nathan Bell.
Assistant Public Defender Casa Movesi on behalf of Mr. Bell, but not with Mr. Bell. Nathan Bell? I have no explanation at this time. I had been in contact with him yesterday.
You were?
Yes.
How'd that go?
He wasn't on the bus, but we were gonna be asking for an adjournment, Your Honor. I have no explanation for.
Bench warrant, 10,000 cash surety. The warrant will issue immediately.
Thank you, Your Honor.
Thank you. I feel better. Thank you. Always looking out for me. Court calls the case, People versus Virgil Dunlap.
Corey Burton Harris, Assistant Prosecutor appearing on behalf of the people.
Your Honor, Edward Jupis on behalf of Virgil Dunlap.
All right. Your name?
Virgil Dunlap.
Good morning, sir.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports. So I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a reduction.
I signed that.
Okay. Nothing else is holding him.
Any objection to the 28th? Probable cause conference, August 28th, 2025, 9 a.m. Bound will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Robert Galett. Yep. Got it.
Asa Bashir for Robert Galett on matter.
Oh, I'm sorry.
Thank you.
Good morning, Rob, on behalf of,
Could you state your name, please?
Robert Gallant.
Okay.
Judge, I apologize. Ms. Reiser, may I approach with our chiefs?
Here now. The request, both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works. Robert.
And we'd request, it's possible to have a 1 week adjournment. I believe Mr.
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
Someone from my office, Mr. Yeah,
What?
there's a trial, Mr. Killawall has a trial in 2 weeks, so it'd be possible to have a 1 week.
Why don't we see what date he's picking, adjourn it?
Probable cause conference, August 14th, 2025.
Go with that.
9 a.m. Bond will continue.
Thank you, Judge, for your understanding.
Court calls case of the people versus Malik Wallace.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Malik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Eduardo Benavides.
Victoria Burton Harris, she's the assistant prosecutor appearing on behalf of the people.
No, I'll wait. Eduardo Benavides.
Be conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask.
There was an issue?
Yes, sir.
Is that Miss Akinruli?
Yes. It's. Yeah. No, she's not.
Oh, she's not the issue?
She's not the issue. Never.
Where is she?
Never.
Oh, Your Highness.
Good morning.
They were talking bad about you. I had
Not
you
Mr.
covered.
Brown, though.
Yeah. Oh, no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it. Apparently they didn't finish. the
Assistant Public Defender Tanat Akinruli, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record, please.
Eduardo Benavides.
Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine.
All right. During the matter, August 14th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you. That's called the case of the people versus Brandon Bowman.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. Can you state your full name for the record, please?
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I could address bond, Your Honor.
Are you going to address the conditional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right, you want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available at 12?
Do my best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bound.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report. Since being put back in for violating the.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your Honor, I haven't seen anything about these calls. My client is saying that he's.
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull it up my internet is not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Robesi, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay, so get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up. Real quick now.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm gonna deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing if.
That I would not be sentencing him to the 8 days on it. for
Understood.
bond. I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm gonna need one for you.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your appendix. I'm just a figurehead. Court calls the case People versus Anthony Miller. He's in.
Your Honor, Alexis Pluma appearing on behalf of Mr. Miller.
Mr. Miller, can you state your name, please?
Anthony Lavelle Miller.
Thank you.
Your Honor, I am going to ask to address bond first, if you would allow it.
It's gonna have to be brief.
Okay,
Otherwise, you're gonna have to file a written motion, show back up at 4.
okay, understood. Briefly, Mr. Miller's bond was originally set because he failed to appear for a hearing last fall. I do have proof here that Mr. Miller at that time was incarcerated in the Wayne County Jail. He was in from September 2024 to April 2025. I would like you to consider a personal recognizance bond on his behalf because he has a part-time job.
How did he come back into custody?
I believe he was picked up.
So he didn't
From-
walk in after
from-
he left his time in jail?
He was in Wayne County, then taken to Oakland County, then transferred here. So he was released from Wayne County at the end of April of this year, then went to Oakland, and then was transferred here. So he was not out of custody at any point in time.
That's what I'm asking.
Yeah.
Said he was picked up.
Picked up from another jail, is I guess what I
Oh,
meant to
okay.
meant to say. And he would be staying at the Delanus Center if released, but he does have his sisters who live in the area.
Any response from the people?
Your Honor, in the court's discretion, charged with retail crime, so he's in custody. But this isn't his fault. I mean, retail crime.
What was his previous bond setting?
He had a personal recognizance bond prior to failing to appear last fall.
Why do I have 25,000 cash surety? Well, doesn't matter. I'll grant that motion. I'll set his bond at $25,000 personal recognizance bond previously declared.
Understood. And Your Honor, I do have a green sheet for him. We're just requesting a 2-week adjournment.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Case People versus Robert Carl.
Andrew Childers, bring on behalf.
Your Honor, Alexis Kumar again on behalf of Mr. Carl. Mr. Carl, could you say your full name?
My name is Robert Martin Carl.
I have before me a plea form that the defendant is going to be pleading to guilty to account 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right. May I have him sworn?
Okay.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? So
Oh,
help you
sure,
God?
I do.
State your name.
My name is Robert Martin Carl.
All right, sir, it is its court's understanding you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs.
I want to be accountable for that, sir. Yes, sir.
What?
I want to be accountable for that, sir. Yes, sir.
Okay, so you understand the maximum penalties in the charge?
Maximum should be a year.
Will be up to a year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir, I do.
All right. And understanding that, do you still wish to plead guilty?
Yes, I do, sir.
All right. You understand also, sir, that I will not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Parr in the 14A2 District Court. You understand that, sir?
I never know that, but okay, sir.
All right. Did you want to discuss that further with your attorney?
My attorney.
You're gonna be sentenced in Italy.
Mhm.
Judge Barr, that's where all your other cases are.
Mhm.
So Judge Simpson's not gonna send you. Come back with me. Italy.
Or we'll just do it here.
Everything. Yes, sir.
All right. You want to proceed?
Proceed.
All right. So to that charge, how do you plead?
Plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
All right. You signed an advice of rights form. Is that correct?
I did that, yes, sir.
Okay. You have any questions regarding any of those rights?
No, I appreciate your consideration, and I'm accountable for the thing.
Okay. I need you to look at paragraph 5 on that form. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, I understand clearly.
You understand you're giving up your right to appeal of right.
That'd be part, yeah, no.
You understand that?
Yeah, I take that, yes.
All right. Are you on probation or parole?
That's incorrect, sir. It's hard no, sir.
Okay.
I mean, no.
Okay. I'll try that again because I want to make sure the record.
No, sir.
Are you on probation at all at this point?
No, sir.
Okay. Are you on parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, no promises made that I did not.
All right. Has anybody threatened you or coerced you in any way?
No, sir, they haven't.
You're doing this voluntarily?
This is the, yeah.
Okay, you're doing this of your own free will?
Yes, sir, that's correct.
All right. And you're also doing it because you believe that you're guilty of this offense, sir?
I am.
Okay, all right. On the date of March 27, 2024, at the location of 220 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes, but no. No, yes, I was. I just go with that. But yes, I was.
Okay, let's try this again.
Yes, I was, sir.
Okay, let me ask the question. On the date that I just mentioned and at the location,
Yes, sir.
did you have cocaine in your possession?
Yes, sir.
Well, did you?
Yes, sir.
Okay, did you use the cocaine?
Given a chance, I would have.
Okay, so you didn't use it.
I did use it. I was using cocaine. I had cocaine and I was using it.
So you did use it?
Yeah.
Okay. Did you know what you were using was cocaine?
I was very advanced on that information. Yes, sir. Yes, sir. Keeping it simple.
So, sir, if any of what I just say is incorrect, let me know. On that date and at that location, you had cocaine in your possession, you used it, and you knew it was cocaine. Is all of that correct?
That is all correct.
Thank you. All right. Now, sir, I have to advise you that if between the time of this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, nor would the judge be bound by any evaluation in this case. You understand that, sir?
Yes, sir, I do. Correct.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court rule and would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be August 13, 2025, 10 a.m. before Judge Barr.
And Your Honor, very briefly, if the court would consider a personal recognizance bond now that Mr. Carl has pled, he does have just recently got his own home in Ypsilanti through a VA housing voucher, and he is concerned about potentially losing that housing if he stays in custody. He does know what he would need to do in order to get out, and this is the only case that's really holding him. He does have other cases out of 14A2 with low nominal bonds set. He could afford to post those, but not the bond on
I'm
it.
going to leave that choice up to, I'm going to deny the request at this point. I will leave that to Judge Barr, who will be able to take everything into consideration regarding this gentleman. So your motion for bond reduction is denied at this time.
Understood. Thank you.
Court calls case People versus Jerry Bigham. So it must have been, he must have been at the time.
Andrew Banner.
Also move basically on behalf of the defendant, Your Honor.
Jerry Bigham, don't bang on my podium. What are we doing?
Yes, Your Honor. At this time, my client is wishing to waive his preliminary exam and seek an offer in circuit court.
Sir, is that correct?
Yes.
Do you understand that a preliminary examination is a proceeding where the people is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes.
Thank you, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive the right. Preliminary examination having been waived, defendant found over to circuit court on both counts. Mr. Bell, please.
Your Honor, we acknowledge the information. Thank you. At this time, my client waives formal readings and stands due to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 18th at 1:30, Judge Fleischer.
September 18th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Sean Dorsey.
Andrew Childers, on behalf of the people.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Dorsey, who's here to my right and beat me here by a mile. State your name for the record.
Sean Dorsey.
Your Honor, this is the first PCC. We are requesting a brief adjournment so that I've had a chance to speak with Mr. Childers so that we can continue to discuss this matter. We're also going to see if we can't work a release to treatment in this case.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court does call the case of the people versus Michael Boyce Smith.
Good morning. Amy Weiser, appearing on behalf of the people. I believe this is.
Yes, it's Miss Ackenruleigh's case once again.
She was just reviewing the
What, she's reviewing what? Video?
video of it, and she couldn't get it open, but ours open.
Oh, was she in with, were you in with your client reviewing video?
I was, Your
You've
Honor,
had
but
quite a week.
it's, I have, you know.
Yeah, I know.
Yes.
Because all of it's happened in front of me.
We've been
It's
together.
been a
all
mess.
week.
I'm surprised you're still standing.
Just hold it together, Judge. Try it. Good afternoon. No, it's still morning. Good
It's still
morning, Your Honor.
Yes, it is.
Assistant Public Defender.
You want me to pass it so you can look at?
No, it's okay. Judge.
Okay.
Yes.
What would you like to do?
We would like to adjourn this matter. The court should be in receipt of a green sheet.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Judge.
Thank you. She said it. It's only been 2 days, but.
And I had a docket after we left.
What'd you say?
I had a docket after we left till 6:30 yesterday.
Did you? You are my hero. Court calls the case, people versus Robin Finney.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Ms. Finney, who is standing to my right. Please state your name for the court.
Yes, Robin Lee Finney.
All right.
And Your Honor, I am hopeful that we will be able to. Oh. I did send over pretty substantial mitigation, including this newspaper article about all the work my client's done in the community to the to Mr. Childers. So he is reviewing that and I think gonna have a conversation with his witness. So we're asking for a brief adjournment.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Okay, I'll just work. Thank you.
Court calls the case, people versus Savannah Bradley.
Corey Burke, prosecutor of your own.
And Laura Yagi, Assistant Public Defender with and on behalf of Ms. Bradley, who's approaching. In terms of the substance of the PCC, Your Honor, we're requesting an adjournment. Ms. Bradley is very eager to get into treatment. We have spoken, unfortunately, she works a lot, so we played some phone tag. I do want to address the bond, issue.
So do I.
Yes. So initially, when I first spoke with her, she indicated that she was not aware that it was such a tight time frame within 24 hours of her release, that she was expected to do an intake. She
Sure.
followed up with them, and she did make contact with them, scheduled an appointment. Unfortunately, she didn't realize it was the same time as a psychiatric appointment she had. So she went to her psychiatric appointment, and then she was basically calling them and calling me, waiting for them to call her back. There was a misunderstanding there. I think it was 2 days ago or yesterday, I told her, just go, don't even wait for them to call you, just go. And she was at work and she wasn't able to get there before they closed. So I did tell her first thing this morning to go, but by the time they opened, she was already here. And so we are asking for the opportunity for her to go test today, or for her to check herself in.
But after that point in time, she had no further contact with them.
So she is saying that she did call them repeatedly after the 23rd. I know that's not in their report, but that is what she is saying, is she called them and she left.
Very clearly says she failed to report for her intake appointment as ordered. No further contact has been made.
I understand that's what they say. She's saying she tried to call them. Her dad is with her in court today.
So, and when she tried to call them, what'd they say to her?
She left a message, I think.
And nobody called her back?
That's what she's saying.
Really?
I just want to make two other points. So first, she is a working mom. She is a 9-year-old. I believe she's sole care 9-year-old, right?
If she went over, would she test clean?
I don't know. I think so. I mean, based on my conversations with her, I will also
I
say,
think that's like a clearest question one can ask.
okay, she's saying she would test clean. And she's saying she is prescribed Adderall, and that's what she would test for.
And that's the only thing that's gonna show up?
Should, yeah,
Will or should?
will,
That's it.
yes.
I tell you what I'm gonna do. I'm gonna give you a shot. She needs to go over right now to community corrections, do her intake, take her test, and if you could let them know she's on her way over. If anything, tell them also that if anything comes, you need to come back over here. But if they get the test before you get back over here and something else shows up, take her into custody.
Understood. She is prescribed the medication, like I said, but
I heard.
understood, Your Honor.
Get over to community corrections. I'll pass the matter. Court calls case people versus Matthew Fonseca.
Good morning, Your Honor. Public Defender Carson Lubez on behalf of Ms. Fonseca, who's present to my right. Can you state your full name for the record, please, Matthew?
Matthew Fonseca.
Thank you. Your Honor, today is the date and time set for probable cause conference. At this time, we're respectfully requesting to set for exam on both matters.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 12. Preliminary examination, August 12th, 2025, in person, before Judge Valvo, in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case, people versus John Altcott.
Yes.
Stephanie Kane on behalf of Mr. Occult, who's appearing by Zoom. Mr. Occult, could you please state your name for the record?
John Paul Alcott.
Your Honor, at this time, we are asking that this be set for a preliminary exam.
Discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available to 12? Pardon?
That's fine.
All right. Preliminary examination in person, August 12th, 2025. 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Bond continue. Thank you.
Thank you.
Court does call the case of the people versus Nathan Gubachi.
Requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
But you thought you had to be right next to her, not in the room?
Where you want me to leave?
Yeah. No, it's always a pleasure seeing you, Mr. Brown.
My pleasure, sir.
All right, so you just stay right there. All right, that makes me happy. All right, what are we doing on this case? Permission to practice it.
Thank you, Your Honor. We're requesting to adjourn this matter awaiting medical records for our office to receive his medical records.
His medical.
Yes, Your Honor.
I mean, I could put it out 2 weeks since he's in custody, but I don't, how fast are they?
May we approach? Prosecute.
Yeah, come on. Came up, that was what it's gonna end up being. Oh, what'd you say? I got it.
May I address bond, Your Honor?
Yes, you may. Let me, go ahead.
I
I was
think,
gonna put it out to August 19th. You're
Thank you.
Seeking medical records. Go ahead.
Your Honor, my client is currently housed at the jail with no bond. In October, he had some medical issues and he has serious medical condition. I'd ask the court to consider at least 250,000, 10% fine so that he can address his medical needs.
Any response from the people?
He would ask the bond.
The magistrate set the bond and denied bond in conformity with the Michigan court rules. I don't find at this point, at least based upon the information for the court, that this court could determine that to be an abuse of discretion. Most where bond reduction is denied, bond will continue as denied.
Thank you.
August 19, 2025 is bond will continue. Got it. Court calls the case people versus Jacob Halfacre.
APA Rachel McDuffie for the people.
Good afternoon, excuse me, good morning, Your Honor. I'm appearing on behalf of Mr. Halfacre.
All right, our understanding is Mr. Halfacre is refusing to be seen.
That is the people's understanding, not only for today's hearing, but for his review with the CFP.
My information, he claims he has a presidential pardon. I did not know
What?
a presidential pardon. I did
Did he
not
get
know
one?
he was a politician. Sorry about that.
Okay. All right, so what do you want me to do? Adjourn this?
Well,
I can't really do much if he's not here.
yeah, December 5th, he was referred to a competency hearing.
I did.
January 10th, he was found not competent but able to regain competency. January 30th, competency hearing, a 90-day review set. April 11th, 90-day review report, still not competent. May 1st, competency hearing set, 90-day review due to competency update. July 3rd, competency hearing adjourned to allow 90-day review. And July 14th, update from Forensic Center, no update. Defendant refused to speak. I'm asking, he has grandparents who are interested in his well-being. I'm asking for some type of bond so he can get out of jail. He's been in there for months. It's a aggravated stalking charge, a 5-year felony. But he's been in there for months now. So I'm asking for some type of bond that can be worked out.
Well, I don't really need a response because I might consider a bond if he were cooperative in the process, but I mean, I can understand, his grandparents. Certainly they're concerned, but if he's not cooperative with this process while in custody, I'm not clear how that's gonna happen if he's out of custody and we can't do anything.
I will contact the grandparents, see if some inroad can be made there.
All right. So what I will do is, I'll have to, I mean, do they need a new order to see him? Do we know?
I can check one moment. I don't think so. I recall reading that they felt like, in their opinion, he remained incompetent and still going to be further.
Got it. Well, right, his status would remain as it was on the original finding, so. Well, let's do this. I'll adjourn the competency review hearing. It's my last date in September, because he's got to see somebody and then a report. I'll set the review date to September 25th, 2025, 9 a.m. If we get a report before then, certainly we can move that date up.
Thank you.
Okay, thank you. It might say he was giving me a party. Court calls the case of People versus Jordan Hartmeyer.
Assistant Public Defender Natalie Pate with him and on behalf of Mr. Jordan Hartmeyer. Please state name for the record, sir.
My name is Jordan Hartmeyer.
Thank you, Your Honor. To my understanding, discovery is complete and I have reviewed and discussed that with my client. At this time, he is wishing to set this case for preliminary examination.
Would people have their witnesses available to 12? Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Yeah. Court does call the case of the People versus Deontay Clifton.
Edward Dukas on behalf of Deontay Clifton.
Mr. Clifton, can you unmute and state, oh, there you go. Can you state your name, sir?
Deontay Clifton.
Thank you.
Thank you, Your Honor. There is some outstanding video that I'm looking to obtain. I'm asking for an adjournment. I am also now on the approved list, so I can speak with him up in the Newberry facility.
Okay.
I have court with him next week, so certainly I will have contact with him by then, but it's been about 2 weeks since I've been able to have contact with him, so.
All right, you want the 19th then?
I'd prefer if we could go.
I can do the 14th, but that means, are you gonna be able to get everything you just said done?
I don't think by then. I'd prefer you had said which date?
Well, I can do the 19th or I can do the 28th.
I'd ask for the 28th.
28th. Any objection from the people?
Objection.
Probable cause conference, August 28th, 2025, 9 a.m. Bond will continue.
Thank you, Ron.
Okay, thank you. Thank you, Mr. Cliff.
You can give me a call. I'm on your approved list now.
Court calls case, People versus Robert Jameson.
Asli Bashir on behalf of Robert Jameson is approaching. And
Your name, sir?
Robert John Jameson II.
Thank you.
Your Honor, we're requesting the earliest available preliminary exam date,
All discovery is complete.
to our knowledge.
People have their witnesses available to 12. Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fleischer. Bond will continue.
Your Honor.
Thank you. Court calls the case of the people versus Lester Braggs, is it?
Michael Gaddy, Assistant Public Defender for Mr. Braggs. Believe he's on Zoom, Judge.
Mr. Brett, there he is. Can you unmute and state your name, please?
Lester Braggs.
Thank you.
Your Honor, we're asking for a brief adjournment in this matter. I believe we have it resolved. It's a matter of posting some restitution. I'd ask the court for 2 weeks to accomplish that.
2 weeks, he'll be able to do that.
Yes, he'll be able to post it in 2 weeks.
Exactly. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
I'll be in touch, Mr. Braggs.
Okay,
Thank you. Court does call the case People versus Chad Jones, all 4 of his cases.
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Jones, state your name for the court.
Chad Jones.
And Your Honor should have a SIP and proposed order to release to treatment in his 4th case, which is the newest one. It's the first PCC for that case, even though it predated his arrest. He's been in custody for the past several
In
months.
his
but,
4th case, which number on that?
the number is apologies, Your Honor. It is the 25 F5 5162.
Okay, I do see that. I'll sign off on that. That I don't have a problem with. All right. And then you want this, you're seeking an adjournment of these proceedings?
Yes, Your Honor.
How much time? I mean,
I think, I mean, he's going to court in Canton in just a few minutes to ask to be released to treatment on that hold. So hopefully a couple weeks, but I'll.
I can do the 14th or 19th.
I guess the 14th. Thank you.
You're welcome. August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Calls the case of the People versus Dominic Brewer.
Andrew Van. Assistant Public Defender Jay Bellinger on behalf of Mr. Brewer, who approaches. Mr. Brewer, can you please state your name for the record?
Dominic Brewer.
And Your Honor, I just got good contact information from my client who was recently released from a different county, so I'm just asking for some time.
Probable cause conference, August 14th, 2000. Well, why don't we do August 19th, a Tuesday?
Thank you, Your Honor.
2025, 9 a.m. Bond continue.
Thank you, Your Honor.
You, sir. Court does call the cases of the People versus Vincent Lambert. No, wait. No, go ahead. I'm sorry.
Like Fatima appearing on behalf of Vincent Lambert.
Your name, sir?
Vincent Lambert.
Thank you.
Your Honor, at this time, we are requesting for adjournment. We are awaiting discovery for 2 of the cases.
All right.
All right. I'm okay with bonding over at Monkey right now. Okay. I'm just trying to speed it all up.
I'm gonna ask, yeah. Your Honor, we would like to address bond when appropriate.
Briefly. I will. Probable cause conference in these cases will be adjourned to August 14th, 2025, 9 a.m. All right, as to bond.
So we'd like to modify the bond to reflect a similar bond by Judge Kunke in circuit court.
What?
Like to modify the bond to reflect a similar bond to what Judge Kunke has ordered in circuit court for treatment.
Okay, so I'm supposed to guess on that, or what was it?
And Judge Kunke's courtroom is allowed to be released to treatment. He's on probation in those cases. And
So he can be released on a PR to treatment?
yes, Your Honor. The people wouldn't have an objection to his release to treatment if there was a tether. We do have some concerns. Sister Lambert does have multiple cases in front of this court. Defense counsel and I have been emailing back and forth, and I think there's some more coming. But
More what coming? Cases?
Yes.
Oh, boy. So, do you have an objection if he's on a tether? Don't ask Brown. Do you have an objection
No,
if
we
he's
don't
on
have
a
an
tether?
objection. No.
Don't? Okay, so I don't have any objection to release to treatment for anybody. You guys just include the tether language in, and somebody will sign it. I mean, I'll sign it.
I have a question.
Sure.
When being released with tether, they require for you to have a phone. Is that going to be a requirement for treatment as well, even though I'm being released to treatment? Because you can't have a phone in treatment, but I don't have a
Correct.
working phone.
And that may be, so let me put it this way. If you have the tether and you guys can work it out, I'll sign the order either way. But that may limit his options of treatment.
No, I'm saying that I don't have a working phone in my property, and tether, the last time I was released, required for you to have a phone before you can.
Correct.
Okay.
And so that's going to cause a problem for you. But somebody may be able to solve that problem. The other problem that is caused is some facilities do not allow the tether and then do not allow the phone, which you would have to operate. Everybody got that? Okay, so he can be released to treatment on a PR. And I'll sign that order. I don't have a problem with that. And so his bond will continue with that modification, so, okay?
Okay, thank you, Your Honor.
Court calls the case People versus Anna Bowman. He's what?
Your Honor, Alexis Plumey appearing on behalf of Mr. Bowman.
Mr. Bowman, can you state your name, please, sir? Yeah, Mr. Bowman, can you state your name?
Need to talk to my lawyer.
Pardon?
Need to talk to my lawyer.
He
Mr.
doesn't
Bowman,
apparently want to state his name or follow the orders of the court. Go ahead.
I didn't hear you. I'm sorry. I didn't hear you. Dr. Adam Baldwin.
thank you. And Your Honor, I do have a green sheet here. We are requesting just a brief adjournment, and Mr. Bowman would also like me to address his bond if you would allow
Well,
it.
we started out on the right foot for that, but go ahead. Take it your best shot.
Understood. Mr. Bowman is currently being held on a $50,000 bond on this case. This is the only case that is holding him currently. He is asking the court to consider a personal recognizance bond. He doesn't have a history of failing to appear for court. He does attend all of his hearings. And primarily, his request is because he's currently enrolled in school at Wayne Community College. And is worried that he is going to default on his loans if he remains in custody, and also worried that he wouldn't be able to get another loan in the future because of this. He would stay away from the University of Michigan Hospital as well, which is where he was seeking psychiatric treatment when this incident occurred.
Response.
The people would request the bond remain as currently set. Chronic defendants are on the sex offender registry, exposed themselves to staff at the hospital. There's in a lot of very explicit threats to staff, including threats of sexual assault, violence against them. Very well maybe related to mental health issues. Those are clearly not currently in checks.
Anything else? Ms. Fuller?
No, Your Honor, thank,
Motion for bond reduction. Anything else? Ms. Fuller?
no, Your Honor, thank,
Motion for bond reduction is denied. Bond will continue.
thank you.
Thank you.
Your Honor, what was the next court date?
14th. Trick question. Yes, 14. Case of the people versus Alicia Cargill.
Children's agreeing on behalf of the people.
On the splits, she's listed as a PD contact, but I don't know that the. I don't think there's Hightower Brown's office.
So I don't have,
So the PD is the attorney of record currently.
because I don't have
So
it.
Lauren Brown, Deputy Chief Public Defender. I believe that we determined that this is a conflict for our office.
Ms. Cargill?
Yes.
Okay. Hang on one second, but I don't have an order nor an attorney for Ms. Cargill.
We've sent it out. I think Mac is probably working on appointing someone. Do you want us, you want me to send someone down there and have? them-
Yeah, but, well, we don't have,
I've spoken to Hightower Brown. I don't believe she has what she.
coded.
No, it is a conflict.
She went now. She's okay. So she's a co-defendant in a case where we already represent with Anitra Kuma.
right, but I get it, but I have no paperwork to
Okay. So
do that. The co-defendant's case is set for what time? 12:30 this afternoon, but I can't do that with.
right. Do you want us
Do
to?
you have any, do you know what you're gonna be doing on the co-defendant case at this point? What,
I believe she's entering a plea.
okay, so it may not matter what I do here. All right. Ms. Cargill, here's what I'm gonna do. Okay, right now, there's a conflict with the public defender's office. I don't know if you were overhearing that conversation.
Yes.
Okay, so I usually get an order down with a new attorney appointed, so I can tell you who that is. I don't have that. So what I'm gonna do is I'm gonna adjourn your case out 2 weeks, because even if I had an attorney, they're gonna need to talk to you. So I'm gonna adjourn your case out 2 weeks, which is the fastest that I can do it. We'll get that order down today, signed, and there'll be an attorney that will contact you, okay?
Okay.
All right, very good. So probable cause conference will be adjourned to August 14th, 2025. 9 a.m. Bond will continue. All right, thank you, Ms. Cargill. Court does call the case, People versus Nicole McCauley.
Asli Bashir for Nicole McCauley.
Nicole McCauley.
Thank you.
Thank you. And Your Honor, we have a green sheet.
All right,
We're requesting a brief adjournment just to confirm some information for further negotiations.
August 14th, 2025, 9 a.m. Bond will continue.
Thank you.
Court calls case of the People versus Xavier Briggs Sumner.
Asli Bashir on behalf of Xavier Briggs Sumner.
Xavier Briggs Sumner.
And Your Honor, we are requesting an adjournment to review discovery in this matter, media discovery that we didn't.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continued. Case of the people versus Ervima Magbury.
Just want to bring on behalf of people.
Oh, Charity.
Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Averma Magbury. Mr. Magbury, state your name for the record, please.
Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of cocaine count. Upon his acceptance of that charge, count one would be dismissed. The prosecutor will recommend and have no objection to the sentence. The defendant is currently under VOP sentence by Judge Conlon and will be in the Washington County Jail until November.
That is correct, Your Honor.
He has signed off on this. Did you mean to check the sentencing judge waiver box?
I did mean to check that.
Pardon?
Is it checked?
No.
Yeah,
That's why I asked.
I intended to check it.
Did you?
I
Okay,
did.
then I'll do that for you.
I appreciate that so much,
All right.
Judge.
May I have him sworn?
Right. You solemnly swear the testimony about to give to be the truth, the whole help you God.
I do. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced in the 15th District Court before Judge Valvo. You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty? Yes? And to that charge, how do you plead?
I didn't hear you.
To that charge, how do you plead? Guilty, not guilty?
Just killing.
Guilty? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights? Please look at paragraph 5. Those are your rights. You'll see a copy there on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes,
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
yes,
June 23rd, 2023, at the location of 900 South Maple, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
yes,
Did you use it?
yes.
Did you know what you were using was cocaine? Finally. All right. Sir, I do have to advise you that if I accept your plea and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, that you would not be allowed to withdraw your plea, and any sentence or recommendation or evaluation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements
No, Your Honor.
that have cost? You want to let me finish? You want to go ahead? That was your way of sort of preemptively saying that you're not aware of anything else.
We are not
All
aware
right.
of any other things.
Are the people aware of any threats, promises, inducements that have led to this plea?
The people are not.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
And defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be August 26, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Judge.
She said that so nice. It's not like Ann. He's on June, Judge. Court calls the case versus Anthony Turner. I'm gonna let her know.
Yeah, Richard McDuffie, people.
Stephanie Cannon, behalf of Mr. Turner.
It's all just a surprise sometimes.
I couldn't hear you.
Yeah, it's okay. No, I'm just,
I couldn't hear you.
Mr. Turner, can you state your name, please?
Anthony Turner.
Thank you, sir.
And Your Honor, we have actually reached a plea in this matter. However, they didn't bring my client over, so I couldn't get him to sign the plea form. Your Honor, if it's okay with the court and okay with my client, I'd ask that I be allowed to sign it with his permission. I had a pen.
No, I'm not gonna do that. The plea form
Yes, Your
and
Honor.
everything.
It's all right here, Your
Has
Honor.
he read it?
We discussed it last week, but
You go through it in detail with him?
I could not, Your Honor. They did not bring my client, so no, Your Honor.
Well, where is he?
He is currently,
He's downstairs.
yeah, he's downstairs. I can go downstairs if you want to call it maybe later today. Is that okay?
Oh, no, that's not happening.
Oh, well, there's that.
There's,
Oh, there's that. There's that. Your Honor, I went to the jail to see him prior to getting the plea form.
I know,
So I'm
I
sorry.
get it.
Okay.
I get it. And you weren't able to get that and go through all of his rights and go through everything with him. I prefer that you do that. I will, although I don't want to, I will give you just a 1-week adjournment. Is he
Perfect.
held on anything else?
Nope, Your Honor, it's just this. He's going to
It's
mental
just
health.
on this one?
Yeah, he's going to mental health court. He's already been, it's all right here.
It's all been, okay, so let me do this. Let me kick it out 1 week.
No, it's not. Pay attention.
Thank you, Your Honor. What's the date you're adjourning it up to?
2025.
You see, he wouldn't let me borrow his pen. I was
What?
like, you see how he wouldn't let me use his pen?
You didn't bring your own?
You know what, Your Honor?
Bond will continue. All right, thank you. Thank you, Mr. Turner. She'll be down to see you and go through those forms with you, okay?
Yeah.
All right, thank you, sir. Court calls the case, People versus Lawrence Buckner. I don't know why you thought you were gonna get support here for this.
Alexander, on behalf of the people, Your Honor.
Yeah, it's just a public defender for Buckner who's in the courtroom, Your Honor, making his way to the podium.
Oh, yeah.
And if you're ready.
Lawrence of the family of Buckner.
Your Honor, we'd like to set this matter for a preliminary examination.
Discovery is complete.
To the best of my knowledge, Judge.
Here, thank you. People have their witnesses available on the 12th. Preliminary examination in person, thank you. Will be August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue, and I might suggest that before his preliminary examination, that he's properly attired or appearing before Judge Valvo. Thank you.
Yes, Your Honor, thank you.
Court does call the case of
Here.
People Brenton Morrison.
Andrew Childers, appearing on behalf of the people.
Really? Can she stay in the courtroom or no? Stubborn.
Assistant Public Defender, Chinazi Carey, I can really, Your Honor, on behalf of Mr. Britton. Mr. Britton, state your name for the record.
My name is Britton Morrison, sir.
Thank you.
Mr. Morrison.
Mr. Morrison. Yeah, Britton Morrison.
Yeah, it's okay. Okay, you would have known that had you been in court.
You are
But that's okay.
right. Judge, we're requesting an adjournment. We're in negotiations with the people. The people would like to know a little bit more about my client, so I want to get some mitigation information together for him.
Will the 14th be enough time for you to do that?
I think that's fair.
August 14th, 2025. 9 a.m. Court calls case People versus Dorian Bulow.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Bulow, who approaches, Your Honor. State your name for the record.
Dorian Bulow.
And Your Honor, my client has been tendered an offer. The offer is contingent upon him paying significant restitution. I'd be asking for 3 weeks at this time.
Pardon?
I'd be asking for 3 weeks at this time.
Okay, so I have like 2.5 weeks or 4.
Okay, I think
So-
if I would prefer 4.
Work that.
Thank you.
Any objection from the people in that regard? Probable cause conference then will be adjourned August 28th, 2025, 9 a.m. Bond continue.
August 28th. Let's say then, okay? We'll talk.
Okay, thank you. Court calls case People versus Melvin Morrow.
If you were to people.
Or yeah, the Assistant Public Defender with and on behalf of Mr. Morrow, who is approaching. Mr. Morrow, can you say your name for the court, please?
Melvin Morrow Jr. Thank you, sir.
And Your Honor, I apologize. This one I didn't submit before the docket started. In terms of the substance, the PCC, we are requesting an adjournment. I just emailed Ms. McDuffie this morning about a piece of discovery that I think would be relevant. I would ask to address bond if possible.
August 14th, 2025, 9 a.m. Briefly, go ahead.
Yes, Your Honor. So Mr. Morrow is here because he missed court just last week. I believe it was just last week that he missed court. He was unfortunately not aware of his court date. He said he was released from the jail without papers and he doesn't have a working phone, but he gave us his case manager's phone number. He's going through an eviction right now. And so things have been really tough. I did talk with him and have a very serious conversation that if he needs to check in with the court every single day, he will do so he doesn't miss another court date. I believe this is the only case that's holding him right now. Is
it?
That's what XJL is showing. Yes, it's just showing this case. When I met with him last night, he indicated he's willing to have on a tether to alleviate flight risk concerns. GPS tracking tether. He's
Are
really
we sure it's his only case? Only because the bond initially was set at a nominal amount, which leads me to believe that he had something else.
So he does have a case pending before Judge Kunke, but it should be a personal bond. And so XJail is showing this as the only case that's holding him in jail.
Well, does anybody know what the bond is before Judge Kunke?
I'm looking right now, Your Honor. My last recollection was that, and let me just confirm this real quick, because I don't know. Yeah, Your Honor, there was a bench warrant issue in that court too. However, he was told that he could do a walk-in on the warrant at any time before Judge Conklin.
Has he done that?
It was for a failure to hear. He has not been able to do so yet because I was able to get a hold of him.
So how did he come back into custody?
I believe, he said he was getting off the bus in Ypsilanti, heard the officer calling his name, or I'm sorry, Ann Arbor. So the officer knew him. So I don't think there's any new allegation of criminal.
But he didn't turn himself in.
Activity. That's correct.
And he didn't appear before Judge Kunke.
So that's correct. My information from him was that he was in the hospital. And so he's had some health issues going on. He's had a lot of family members pass away recently and he's been evicted, going through that process. So he's had a lot that he's been juggling. But
at this time, I'm going to deny your request and then you can certainly bring it back before the court once Judge Kunke rules on his and he gets before her.
Understood, Your Honor.
Take another look at it.
Okay.
Bond will continue. Thank you. Calls case People versus Kevin Burden.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burden. Mr. Burden, can you please state your name for the record?
Kevin Burden, sir.
And Your Honor.
Waiting response for the mitigation packet.
That is correct, Your Honor. We're still working on that. I think 2 weeks would be sufficient if that works with the court.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continue. Thank you. Thank you. I'm just letting you know that. I'm just pointing out facts. Court calls a case. People versus Stefan Wainwright.
Oh, it's unmuted. Hey, Your Honor, before my attorney speaks, I want to change something. Because I
Want to do what?
want to change something. So I signed yesterday to have my preliminary exam waived, which I don't want. We actually spoke about an insanity plea thing, and I wanted to move forward with that because I am insane and I was looking to get help.
Hey, well, hey, all right, Judge. Go ahead, what? All right, thank you, Mr. Wainwright. Yeah, go ahead.
Student
Yeah.
attorney Kara Rosencrantz requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Wainwright.
That is the first time you've done it reluctantly. But permission to practice is granted.
Your Honor, I suppose we'll be requesting an adjournment in this matter. I'll-
All right, Mr. Wainwright, here's what I'm gonna do, because obviously you did something with your attorneys before, and I thank you for pointing that out. I'm gonna adjourn your case out so they can talk with you a little bit more about what exactly is going on right now, okay?
Thank you.
You're welcome.
Thank you, Judge.
Probable cause conference, August 14th. Will that be enough time or you want the 19th?
14.
Whatever's. Oh, he says 14.
Okay. But given what he said, is that who I should be listening to? Never mind. Don't answer. August 14th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you. Have a good day.
Now, Ms. Cannon, you should make that admission sometime. Court calls the case, people versus Brian Ginyard. Gerard, excuse me.
Andrew Childers appearing on behalf of the people.
What? They're not at the door. He's in custody. All right, let's go to this next one. Court does call the case of the people versus Maurice Burgeons.
Victoria Burke Harris, Chief Assistant Prosecutor, here on behalf of the people.
And Laura Yagi, Assistant Public Defender, with and on behalf, hopefully of Mr. Bergens. Mr. Bergens, can you unmute yourself and state your name for the court?
You have to be here first, right?
Yes, I was talking with his partner, who I had thought was logged onto Zoom earlier. I would ask if the court would consider briefly passing so I could give him a call. Or waiting until the end of the day to issue the warrant. Please, Your Honor.
Bench warrant will issue fine 10,000.
Your Honor.
Just listen.
Okay.
No, go ahead. You now interrupted.
No, I'm sorry.
No, go ahead.
I was just gonna ask if I'm able to get in
This
contact.
bishop
with
was
him.
appalled. Go ahead.
If I'm able to get in contact with him, and I have an explanation for what's happening by the end of the day, would the court consider recalling the warrant?
Yeah, but I didn't finish, so I was gonna do that. But Ms. Yagi, man, thought I might do something really good.
How you like your stickers?
I do. I put the sticker on already. Thank you, ma'am. Did I get to the bench warrant part before she interrupted me?
I will be honest, I
Oh, don't know. I'll start over. Bench warrant will issue for defendant's failure to appear by the amount of 10,000 cash surety Ms. Yagi, that warrant will not issue until Monday, the 4th.
Thank
So
you.
now you have nothing to say, right? All right.
Now I would say thank you. Thank you, Your Honor.
Court calls the case of the People versus Brian Gerard, 2 cases.
Every children's agreeing on behalf of the people.
Like a Fatima appearing with and on behalf of Brian George. Please say your name for the record.
Brian Gerard.
At this time, we are waiving to circuit court for a global resolution.
So he's waiving on both of these cases.
Yes.
All right, sir, is that correct?
But yeah, yes.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
So I'm doing right now is waiting. Yeah. I didn't know any of that. Yes.
All right. You understand you will not have that hearing on either one of these cases and that you'll proceed to circuit court for further resolution.
Yes.
And that's what you want to do, sir?
That's what I got suckered into yesterday. Yep.
Okay. People also waive their right on these cases.
Yes, sir.
Preliminary examination having been waived in both cases, defendants bound over on the single count, each one.
Yeah, you guys said no president.
Counsel, you acknowledge receipt of the information waiver at reading? Or not? You're not listening. Go ahead.
We acknowledge the receipt of the information and we waive its formal reading, and the client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. A pre-trial in this matter will be set for
At 1:30 with Judge Fleischer.
August 11th, 2025, 1:30 before Judge Hammoud.
I'll be there.
We'll provide the transportation. Bond will continue. All right, sir, thank you.
Thank you, Your Honor.
This one, just like this one. They need to go now, so then they can sign off on the thing. So just do that other one, hand those to Alan, so you can take over. Court does call the case, people of the state of Michigan versus Michelle Campbell.
An Assistant Public Defender Jay Bellinger on behalf of, but not with Michelle Campbell, Your Honor. I made several attempts to get a hold of her. I know in talking with Ms. McDuffie, we were planning on adjourning this matter. I would ask for that. I understand she had some health problems last time she was here, so my concern is for that at this time.
That she had what?
She had some health issues last time she was here. So I'm concerned about her well-being at this point. I have not been able to get a hold of her.
Why are you rooting for him? People have any objection to an adjournment?
No objection.
Really? Finally, the first case, you're gonna be cooperative. Never mind. Never mind.
I have some available.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Your Honor.
Bellinger, if she doesn't show, I'm taking you.
Yes, sir.
All right.
Thank you. I know you have a whole arsenal, so.
I sure do.
Court calls the case, people versus, is it Ibid Timmy Abuzula?
Alexander on behalf of the people, Your Honor.
And Stephanie Cannon on behalf of Mr. Abguzulu, who is to my right. Could you please state your name?
Vitimi Alexander Buzulu.
Okay. What are we doing?
Your Honor, we're just asking that this be set for a preliminary exam.
Discovery is complete.
Yes, Your Honor.
It's a terrible story. People have their witnesses available on the 12th. Preliminary examination, August 12th, 2025, 9 a.m. before Judge Fleischer.
Your Honor, my client is wanting to know whether or not the court would kindly allow him to have his calling privileges back. He understands that he should not have made any calls. Will not be doing so in the future, concerning the complaining witness.
Your Honor, I would object at this point, given the nature of the calls and why his phone privileges were revoked. I would ask this to be something that could be addressed at exam, given that he was trying to have third parties reach out to the victim. So I would ask that those that his privilege is stayed revoked at this time.
Anything else?
Nothing, Your Honor. Thank you.
All right, I will deny the defendant's request for modified bond. Phone privileges will remain to vote. So case, people versus Kamani Hamilton.
For two very people.
Just on behalf of Mr. Hamilton. Monty, can you state your name for the record?
Imani Hamilton.
Judge, I've had a chance to speak with him. We set an exam in this matter, Your Honor.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
Judge, I have a trial that day. We make it the week after.
Oh, that's right. So the 19th.
That's possible.
Preliminary examination, August 19th, 2025, 9 a.m. It's in person before. It's actually will be at noon, 12 noon, and that's before me.
All right, thank you, Judge. Monty, I'll come and see you.
Bond continue. Thank you,
Judge.
sir. Court does call the case of the people versus Stefani Cash.
And Public Defender Natalie Pate with and on behalf of Ms. Cash, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Cash, you have to unmute.
Tiffany Cash.
All right.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I am respectfully requesting an adjournment. I did discuss this matter both with my client and the people. We believe we're missing some photos from discovery, so we are asking for an adjournment to get those.
August 14th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Ms. Cash. That's for today.
Thank you.
Case people versus Abdel Osmond.
Only again, Your Honor, Constable based on behalf of Mr. Abdul Mohsen Osman, who is present to my right. Can you state your full name for the record, please?
Abdul Mohsen Osman.
I heard it. That was perfect. Your Honor, we're going to be requesting the briefest of adjournments. We just need discovery. He was recently arraigned, so we did put in the request. We're just awaiting.
August 14th, 2025, 9 a.m. Bond will continue. So you'll wake up. Close the case. People versus Antonio Cornelius.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cornelius. Mr. Cornelius, please state your name for the record.
Antonio Cornelius.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. I've had a chance to speak with the prosecutor in this matter. Both agree that mental health court referral is the most appropriate. So we'd like to adjourn this matter while we get that referral going. I think what the amount of time, 3 to 4 weeks maybe.
To get the whole, because you got to get the screen. Okay.
Right.
Any objection from the people?
Okay.
August 28th, 2025.
August 28th?
Yes, sir.
All right, thank you.
Bond
very
will
much.
continue. Thank you.
Yes, sir. Thanks for waiting. It's been a while.
Court calls case people versus Glenn Pennington.
Andrew Childers appearing on behalf of the people.
Lady.
Possibly be sure on behalf of Glenn Pennington. Pennington, if you could say your full name.
Oh, Glenn Pennington.
And Your Honor, we're requesting a brief adjournment, just to make sure that we can get some medical information for Mr. Pennington.
Said medical?
Yeah, for negotiations and also to potentially address bond.
Okay, I get that, but are you trying to retrieve that from a health facility, healthcare facility?
Yes, yeah, we need to get some release signed.
All right. Now, during this probable cause conference, August 19th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Right, thank you.
Yeah. The way you said
Court calls the case, People versus Donald Wicks. Oh, she showed up.
Asli Bashir on behalf of Donald Whitsett. And Mr. Whitsett, if you could say your full name for the court.
Donald Deontay Woodson.
Thank you.
And Your Honor, today's the date and time set for a probable cause conference. My understanding, and you correct me, Mr. Childers, I'm wrong.
Your Honor, there was, Mr. Whitsett had some cases pending in front of Judge Mood in the circuit court. There was ultimately a resolution on those that was supposed to include a disposition on this. This case basically was authorized kind of in error. It was supposed to not have been charged. So people would be moving to this case.
No objection to that.
No objection, Your Honor.
Case is dismissed. We'll need a valley. Okay. Thank you, sir. You're all set.
Okay.
Court calls case People versus Garrett Pentago.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Finagle, who approaches. Can you state your name for the record, please?
Garrett Pinagle.
He's waiving preliminary.
He is waiving preliminary examination, Your Honor, and at the appropriate time, I would just ask to address bond.
All right, sir, you're waiving your right to have a preliminary examination in this case?
Yes, sir.
And you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading, stand mute at this time.
Defendant every way from a reading standing mute, court will enter a not guilty plea. Before I set the pretrial, go ahead, argue bound.
Your Honor, my client has been entered into the sobriety or the recovery court in the circuit. He is an individual who would benefit greatly from that. However, I am asking for an opportunity for him to be released in the interim on a sober link device. I have talked to Mr. Childers about that, who didn't seem to have a problem with it. And I asked that for reasons. There are some underlying safety concerns in the jail that have been brought to my attention regarding my client. And I can provide to the court that he does have a place he can stay in Whitmore Lake with a family friend who has been present for him in court every time that he's had to court.
Any response?
Your Honor, people leave it up to discussion of the court. I would not have an objection provided that Mr. Bell's on either silver link or strength.
Is he with Judge County's court currently? Is he in that program?
I don't know if it's going to be on, I believe that might be on Judge Slay's track, Your Honor.
Got it. Okay, so, but I guess what I'm saying is he in the court, at the sobriety court?
Yes, he has been accepted.
He's been accepted. Okay, and that's Judge Slade? Oh, gotcha. Okay. All right. What happened? Did he not show up for me or something? How did he end up in custody? Because I have his original bond, well, bond was denied. Did we have, we've already had a violation, haven't we?
Your Honor, I believe, my understanding, if I recall correctly, was that he did not come at a certain point. He was an earlier FTA on the case.
Yeah, this was in.
Well, no, there's a community corrections violation.
I remember something from March.
Yeah, so here's my problem. I would have I'm gonna deny the request because I have a previous community corrections violation from March. And then at some point, he also then failed to appear.
Okay.
So while I'd be inclined to do it, given that, I'm gonna deny the request for any modification of bond. His bond will continue.
Oh, we're waiting on a date.
All right. And so then in custody, pretrial date will be set
August 12th at 1:30 for Judge.
August 12th, 2025, 1:30 before Judge Conkey.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case People versus Mario Crawford. And we reach.
Stephanie Cannon on behalf of Mr. Crawford. Oh, you know what?
We're gonna need that.
Mr. Allen, take this one too. This is the other one.
These are late ones. Scott and then Crawford. Right? I can see it. What?
That was difficult. I was like,
What was it? Is this the one you didn't turn in that you're now trying to turn in?
yes,
Is that it?
yes.
What took so long? That was like hours ago.
Chinazo.
Okay, so that one goes into a file that's probably long gone. All right, so we're back on Crawford.
I'm just requesting an adjournment. He's in.
Why you?
He actually is no longer in custody. He was released. Wait, I talked to him. Okay,
What?
nothing.
You said, no, you were about to yell at Ann. Go ahead.
No,
That's the
I
way it
would
works.
never.
No, you were about to, Ann said something, you were like. I mean,
That was a
no, you were looking at it like,
vocalizing
no, got
astonishment.
it wrong. That's how you were looking at it. So I wanted that to go ahead and see how that worked for you.
Yes, Your Honor, my client was in lockup on Tuesday when I went to see him regarding this case. We were asking for an adjournment for mitigation purposes.
You told him when his court date was.
I did say we had court this Thursday, yes, sir.
Issue for its failure to appear.
Thank you, Your Honor.
Bond will be set in the amount of 10,000 cash surety. I don't know why I'm doing this. I will not issue that until the 4th, so you can try to find it.
Thank you, Your Honor.
Court does call the case People versus Stephen Ruggs.
Alexander on behalf of the people, Your Honor.
Mr. Ruggs, could you state your name?
Stephen Ruggs. Thank you.
At this time, Your Honor, Mr. Ruggs is requesting that the court set a date for his preliminary exam.
It's all discovery complete.
Yes, to our knowledge.
People had their witnesses available to 12.
Yes, Your Honor.
Preliminary examination in person will be set August 12, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
All right, thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Kniper.
Alexander on behalf of the people, Your Honor.
Apologies, Your Honor. Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Nieper. Your Honor, I have had a contact with my client as of yesterday, understanding that there's a bond violation in this case. He and I had a heart-to-heart. He is checking himself in, and I did show some form of proof to Ms. Zenda regarding his admittance to Bear River.
And that's correct, Your Honor. I did see that verification.
So is he in and headed up there?
He's already up in Traverse City, Your Honor.
So they've already taken him.
They will be taking, he's in that process. He's a day away from it, is my
Stay away
understanding.
from the Bear River.
Yes, Your Honor.
So what would you like me to do?
Your Honor, I would ask for an adjournment at this time. I would ask for 2 weeks, just so that I can make sure that he's in, and that he sends us the admission paperwork.
Any objection from the people?
No, Your Honor.
Probable cause conference, August 2025, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Case People versus Barrage Scott.
And Assistant Public Defender, and I declare Your Honor, on behalf of the Barrage Scott, who is approaching. Mr. Scott, when you reach the podium, could you state your name for the record, please?
Yes. Rise on take, Scott. All right. Did you hear me?
Yes, I can hear you.
Okay, I'm sorry.
No, it's okay.
Judge, we are requesting an adjournment today.
Okay.
It's my understanding that Mr. Scott is going to be arraigned on Monday. Arraigned on a, I think it's an older charge that was just authorized. Did you confirm that?
I didn't see. I don't know where that is.
Well, Judge.
Maybe when I looked over, I think maybe there's.
So another felony?
Yeah.
That's my understanding, Judge.
So, and if he's arraigned on Monday, the 4th, and he would get the 14th. Okay. So let's adjourn these out. I'll wait for the green sheets.
Okay.
But let's do August 14th, 2025. And if he does get arraigned on Monday or sometime in that week, they'll set it for the 14th. If you could note, so he doesn't get 2 dates, just to have whoever the arraignment attorney requests at the magistrate set.
Absolutely, Your Honor. Thank you very much, Judge.
All right, thank you. Bond will continue in both cases. I mean, yes. Is that her?
I didn't receive anything.
What did she say? This is my last. Out. Court does call the case, People of the State of Michigan versus Savannah Bradley. Recall.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Laura Yagi, Assistant Public Defender with on behalf of Ms. Bradley, who's approaching. Ms. Bradley, can you state your name for the court?
Savannah Bradley.
We have her test results.
We do, Your Honor. And it does look like the only positive is the amphetamine, which I think would be consistent with Adderall usage. Every single day she takes her Adderall. I know there are numerical values for some of the other substances. However, the outcome is listed as negative. So
It doesn't meet a threshold. I understand how it works.
So I would ask the court to, and I have had a very real conversation. Ms. Bradley, in all candor, was very terrified of being arrested in court today. And she came to court knowing there was a violation report, knowing the likelihood and possibility of arrest. And we had a conversation about that. She understands how serious it is to call community corrections every day and text. And she is very interested also in seeking seeking help. So that's something that we're working on together. So I would ask the court to continue her bond and adjourn the PCC.
During the PCC to the 14th, 2025, 9 a.m. It won't. Did you get yourself enrolled?
I
When you were over
I can today.
today? They enrolled you?
Wait.
So did they give you like a color?
Oh, no, sorry.
Okay, we may need a new order. So you need to go back over there. I'm gonna prepare a new order so that you get yourself enrolled and that you do then, as Ms. Yagi is indicating, call them every day and follow their instructions. You understand that?
Yes.
What did I put that? Okay. Fine, we'll continue.
Thank you.
Thank you.
Court does call the case People versus Marina Sexton.
Bailey's in on behalf of the people, Your Honor.
All I have is.
Yes.
To do this.
Thank you, Your Honor. Costin Bilbese on behalf of Marina Sexton, who's present to my right. Can you state your full name, Marina?
Marina Sexton.
Thank you.
Your Honor, we're going to be requesting an adjournment for Padilla reasons, as well as to continue negotiations with the prosecutor's office, and I'd like to address bond when appropriate.
Yeah, you can. I'm gonna. Okay. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Yes, go ahead. As bond.
Yes, Your Honor, I'm going to be asking for a PR bond for my client. Your Honor, my client has no criminal history. She's been in for 11 days. She's currently pregnant. She also has been served divorce papers while she's been in jail that are related to this case. She wants the opportunity to be able to seek counsel for that. She's willing to go on a tether. She's even willing to submit her passport for the court to hold if they deem that appropriate.
Counsel approach. Right, in this matter, record should reflect your head bounds conference in this case. probable cause conference, I'm gonna actually adjourn this to the 14th, 2025 at 9 a.m. With reference to the defendant's bond, was there anything else from the people?
No, I was just put on the record that we would object, on the record.
All right. I am going to, I'm gonna grant the defendant $25,000 personal recognizance bond, so I'm gonna lower her bond. I will, the defendant is to report over, well, I want a GPS location tracking tether prior to release. Okay, thank you.
Thank you.
All right, and ma'am, your counsel will explain to you some other implications that I explained. So, okay.
Thank you, Your Honor.
Thank you. Court does call the case People versus Colin Spry.
Andrew Dennis.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Colin Spry, who is approaching. Please state your name for the record, sir.
Colin Joshua Spry.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. Mr. Banis did relay to me yesterday evening that the people have authorized a new case against Mr. Spry. However, it has not yet been sworn to. Me and my client, I have discussed this with him. He is hoping to keep his cases together. So I'm asking for an adjournment. I would not frankly know how long, maybe a couple weeks, but I don't know if it'd be accomplished by then or not.
Here's what I'll do. So that I'll put him out to August 19th at 9. So that if it does get arraigned, put it on the 14th. From the 14th, we can move it to the 19th.
Sounds good.
Maybe with this one. All right. I guess the only thing is if it gets set for the 14th, then we'll just kick it out to that day. Okay?
Thank you, Your Honor.
Bond will continue. Court does call the case People versus Derek Stevenson.
Morning, Your Honor, Jacob Kennedy for the people.
How you doing, Your Honor?
I'm doing well. Yourself?
Mr. Gaddy.
Assistant Public Defender Tanazi Carey, on behalf of Mr. Derek Stevenson, for Mr. Mike Gaddy, Judge. I apologize, Mr. Gaddy just told me. How you doing, Mr. Stevenson?
How you doing?
All right, you're requesting an adjournment.
We are, Judge.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Yeah.
Thank you.
Thank you. And get a seat at the table. Slow, in custody, they're not there yet.
No.
So.
What'd you hear? Why, you know what?
Calls case, People versus Fred Willis.
Andrew Schiller's appearing on behalf of the people. We're ready. Jake Kennedy appearing on behalf of the people on the further section of the matter.
Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Willis. Mr. Willis, please state your.
Fred Willis.
And I believe that will be, well, we still need additional discovery. I believe that's already been requested. So there'll need to be an adjournment in this matter.
Conference will be adjourned August 14th, 2025, 9 a.m.
Thank you very much, Your Honor.
Bond continued. Let's call the case of the people versus Douglas Wren. Oh, we'll wait. I'm sorry.
For Yaki, Assistant Public Defender, with and on behalf of Mr. Wren, who's approaching. Mr. Wren, can you state your name for the court?
Douglas Allen Wren.
Requesting an adjournment.
Yes, Your Honor.
So there's a question about his participation.
So he's in recovery court, but by